two heads of civil service, one incumbent, the other a former head of civil service, and they more or less anchored the conversation with their presentations, and we were greatly assisted by their intervention. We were going to devote today to the state enterprises. They are currently not covered by the Constitution as we've read it, and I think others agree that the state-owned enterprises, to the extent that they are commercial ventures, escape constitutional scrutiny in the current Constitution as in previous ones. So we were going to devote today to looking at that omission and whether or not it was not time to bring those state assets under the scrutiny of the Constitution, the same way we do with other state resources like natural resources, which are also, of course, of commercial value. But I think we can continue the conversation on public services. We can spend maybe one half of this morning talking about the public services, because yesterday we were talking about the Public Service Commission behind their back. But today I understand that they are very fully represented in the room, and therefore we would take advantage of their presence to give them audience and have them also share some perspectives with us. So while we will still discuss the state enterprises matter, I think before that we would want to hear from the Public Services Commission. Some of the things we discussed yesterday on that issue had to do with the atomization of the public services into many different services, a process that appears to have no end. We reflected yesterday a bit on its impact on the public, the politics and partisan interference in the work of the public services. We discussed the retiring age of 60 and what we might do about it, whether to not even consider removing the matter completely from the Constitution and leaving it to legislation because of the fluid nature of the policy issues around retiring age. I think we also looked at, we touched also a bit on the state enterprises question. We looked also at the independence of the Public Services Commission, the mode of appointment, the functions of the commission, and its ability to exercise the functions or the powers or the roles that are assigned it under the Constitution. Essentially, the idea, what we are looking for is a public administration that is fit for purpose for the country, that can propel development consistent with the experiences of the developmental states and others where clearly the public services have been key. We talked about how we could deal with the problem of messy transitions when there is party turnover in government, and how we could use the public services to smoothing those transitions and make them more seamless and less turbulent based on the experiences that we have had. So these are some of the issues that we reflected upon, and we would be glad to get the perspective of the Public Services Commission on some of these issues. So you are invited to take the floor. We'll have about 15, you can speak for about 15 to 20 minutes, and then we'll have a round of questions and discussion on the issues. Thank you. But before then, I think we'll go around the table like we did yesterday, introduce ourselves, starting from my left hand, the far end of the table, of the round table. We have reconfigured it from yesterday so that it looks round as opposed to rectangular. So, the gentleman, okay. Yes, you can start.
Good morning. I'm Techi Eduamankwa, a research assistant for the CRC.
Good morning. My name is Victor Azuri, and I'm a legal researcher for the committee.
My name is Fatih Bodua Seidu. I'm a director at the Public Services Commission.
My name is Mabel Amwakwata, secretary to the Public Services Commission.
My name is Nana Ajima Frimpong. I'm a member of the Public Services Commission.
And I'm Irene Stella Ejenim Boateng, the Vice Chairman of the Public Services Commission.
Thank you, Chair. I'm Victor Ajman, Chairman of the Public Services Commission.
Thank you. Michael Nanaya Eduhene Edudako, a member of the Public Services Commission.
Aretha Bamford, Legal Research Assistant for the CRC.
I'm Hiba Abdul Nasser. I'm the Legal Research Assistant for CRC.
I'm Patience Asabagna. I'm a Legal Research Assistant for the CRC.
Reina Kumperge, I'm the Secretary to the Committee.
H. Kwesi Prompe, Chair of the Committee.
Ibrahim Tanko Amidu, member of the committee.
My name is Kwame Kakari, member of the committee.
Thank you. My name is Godwin Jokoto. I'm a member of the committee.
Hi, I'm Agatha Roxon, and an academia and a lawyer.
Kweku Entry Boesiakon, Project Coordinator, CRC.
My name is Doche Chikata. I'm a lawyer, a private legal practitioner.
Hi, my name is Bless Yibarak El Solti. I'm a law student, interested individual. Thank you.
My name is Nimoi Thompson. I'm the chairman of the National Development Planning Commission. I also wear a subsidiary hat as an advisor to the president on the SDGs, which has a great deal of interest in the topic of the day. Thank you.
Good morning. My name is Nana Kwesia Jikum Dramana. I don't know, but I'm hanging around.
My name is Stanley Courage Duga, representative of Roundtable Dialogue Rescue Ghana Mission.
I'm Kwesi Mfedra. I'm a legal research assistant with the CRC.
Okay. The rest of our members are online, as are some of the participants in today's conversation. They will join us as and when they take their turn during the Q&As, but we have Dr. A.C. Ansah and Mrs. Charlotte Osei, who are both members of the committee and are joining us online. Oh, sorry. And Justice Sophia Adinyira, another member of the committee, is also joining us online. So all the women of the committee are online, leaving the guys here. So this is a full house in terms of the committee membership. I think I've seen Senor Hosi has also joined us. And the Honorable Ayiko too, who has become de facto 9th member of the committee, because he has been with us since the beginning, which is last week's discussions on natural resources and lands and on local government and decentralization. He's been with us through that, and was here yesterday. So we have a full house today, and thank you all for coming. So I will defer to the Public Services Commission to make a presentation. Thank you, sir.
Thank you. It's just because I'm not as tall as Nana, so usually I prefer to stand. But thank you. We are indeed grateful for giving us the opportunity to be here. The invitation came in a little bit late, otherwise we would have prepared a PowerPoint presentation. But earlier, we had made a submission to the committee, which we believe addresses a lot of these issues. I would like to take about a minute to give the historical. There was a Harrigan committee in 1947 that recommended that there has to be established an independent public services commission. And then in 1948, it was established. And since then, at every constitutional, review or even in any constitution, the public services has featured prominently. The reason for setting up this broad thing was to ensure that we have some standards for the public services, because it was so broad that if we were to leave the individual public services to do things on their own, it was going to end up in chaos. So the public services was set up to ensure that there is fairness, there's transparency, there is impartiality in the operations of the public services. And therefore, in our view, this is our view, in setting up the public services, it clearly, distinguished the human resources from the operational side of things. And this is where you have the executive actually overreaching from operations into even human resources, the appointments, the termination, and the management of all the public services. But there is the need actually to maintain, and that comes to the independence of the public service. And if you look at the 1979, it talks about the fact that there was the need for a controlling body which will be in charge of the public services in order to ensure that, it protects the public servants. However, the Public Services Commission was not strong enough, if you put it that way, to be able to protect the public service. So even in 79, there was the perception, let me put it, sorry to use perception, but they sat down and realized that there was a tendency for the executive to influence human resource management in the country. And there was the need to set up an independent body, clothe them with enough power to be able to both advise and take decisions which would protect the public servants. So one of the main objectives of the Public Services Commission is to be some form of a protector. And that is why you need to give them that independence to be able to take some decisions and to maintain that. Let me give one typical example. That previously what the commission has done is that we call some people category A. That is chief executives and deputy chief executives. If the president makes an appointment, which is not in the act, some acts do not make provision for deputy chief executives. So even if the president appoints, we will not process that. we will inform the president that it is a position which is not in the act, and therefore take the necessary processes to amend the act. For example, Forestry Commission, let me give a typical example. At the last thing, they had executive directors who are supposed to be deputy chief executives. But His Excellency, the President at that time, appointed three deputy chief executives. So in effect, you had 6 deputy chief executives when the act did not make. So we did not process that. The effect is that you cannot be paid through the mechanized payroll. But they found some way of, paying them. It has not cured the mischief. The mischief is to ensure that there is some sanctity in the public service. But the executive is so powerful that they can decide that even if it's not there, that is the situation. We met with the Attorney General, and what he said was that the president's prerogative is to appoint. We cannot take that away from him. Ours is to advise him and to ensure that we do not. But that is where we believe the challenge is. And if you look at, if I could go, sorry to be moving up and down, but I was going to go to the appointments and once I've talked about this, let me focus on appointments. Now you have a system where the president appoints on the advice of the board, given in consultation with the Public Services Commission. In the past, what happened was that there was an advert by the board. First, the board was constituted. The board would advertise. The board will shortlist 3 applicants, and they will refer the applicants to the Public Services Commission. We will look through their CVs and find out if they meet we call them person specification. And the person specifications are that you need to have served as a CEO 15 years in the public service. You need to have a master's. You need to belong to a professional body. And the 4th thing is that your appointment should be in the act. If all these are not met, we will not actually process your appointment. And then after the interview, we would have a first, second, and third, just like in the universities. That then goes to the president. And the president has the right to now choose any of them. However, over time, the executive said that we cannot make, that process is taking away the president's ability to appoint, because you are giving the president 3 options and say choose. So the president has no this thing but to go within that. So that came in the advent of a green letter of appointment. So now the president says, I will appoint, or we call that nomination. I will make initial appointment. Then it comes to you, to the Public Services Commission. Look at the person. If you think the person is suitable, then advise me by an advice paper. And then the president will sign the advice paper, and then we issue out another appointment letter. So in the public services, you have 2 appointment letters currently. There's a green appointment letter, and there's a white appointment letter. And most people, once they've got the green letter, do not even want to come for what we call processing. There are 2 broad agencies, those which are subvented, which needs to come to us to be put on the controller's payroll. They will come. The non-subvented, and all other agencies, once they get the green paper, they don't even bother to come. So there is no way of assessing whether these people are suitable with that. So that is one of the major challenges, where does our advice come in? So if you look at what we proposed, in actual fact, we proposed two. The third one, we were afraid to even propose that. That is because it had come up in all the constitutional review to take away the president from making appointments, and that had not, it had been shut down in all cases. So we were even afraid to put that up. So we said that the next one, which might be a little bit this thing, is to have the prior approval. The president still makes it, but there should be a prior approval of these public servants before it is made public. So it means the president will still appoint, but it will come to the Public Services Commission for the Public Services Commission to have done the due diligence, gone through, interviewed them, then get back to the president. Then he can then announce that. So that is what we have said is the preferred. In that case, we'll be sure that these will be covered. Otherwise, we can tell you that there has been almost 20% of the people who are appointed do not go through. We do not. But usually you inform the president because it's an advice. They will tell you that go back, re-interview the person, and appoint. So wherein lies the independence? Because it is only an advice to the president. Some people come in and they do not even know the act, the enabling act that they are supposed to deal with. They do not know government policy. When they come in, all that they tell you is that the president appointed me and gave me specific instructions. But these specific instructions, you need to perform within the public services of Ghana. There are certain rules and responsibilities within the public services. For example, let me give a typical example. Within the public services and by a constitution, ministers are not supposed to terminate appointments. It is the board and the presidency. But you find out that ministers are terminating, CEOs are terminating. These are against public service rules. But because of the nature of the powers that we have, we will have to go back to the presidency to say that these people are not going according to this thing. We do not have that power. So that independence that is given, yes, it is there in name, but the powers that go with it are not that strong enough to bring sanity within the public service. And so that is what we think, that the independence must be maintained, the powers need to be strengthened, not really as a check on the president, but to be able to communicate these things, and for the executive, let me put it, to listen to us. Otherwise, there are a lot of things that are going on in the public services. We do not agree, but we are unable to do that. We are amending our act to try and give some powers to sanction. But the question is, what will be? So I have dealt, Chair, with the independence. If you look at the public services, and let me give a rundown of the public services. We have what we call Article 190 will just list the public service. But for ease of management, we have developed what we call the central management agencies. Because when you take just the Ghana Tertiary Education Commission, GTEC, they have under them 170 public services, universities, technical and university. They have colleges of education, that is around 46. Then they have colleges of nursing, that is also around that, and also some other 156. But they manage it at that end, and then we oversee them. In the same way, that is how we think, that is how SIGA operates. Even though Article 190 takes away commercial entities, the law makes SIGA an oversight this thing. But SIGA is part of the public services. So SIGA becomes a central management agency. And then you have where Nana came in. He's my mentor, and Nana Jamana, civil service. Nana Ajekum Jamana, yes, he's particular about that. They also oversee the ministries, now 25 and all that. Then you have local, Office of the Head of Local Government Service, 261, coordinating directorates. So you have the security agencies, which we have oversight, but it's only in name, only. Judicial service, parliamentary service, we have oversight, but it's also in name only. So these are the challenges that we have. And then there are the almost 220 agencies. But the challenge is that they move to the ministers instead of to the Public Services Commission. So you have ministers performing human resource function, ministers transferring people, ministers, as I indicated, terminating the appointment, ministers even appointing. In the previous thing, ministers made the appointment. We refused to process the appointment till they had the presidential, appointments. So when you put all this, we are doing a good job in more or less providing oversight. Otherwise, there will be chaos. So there is the need to strengthen. So I've talked about independence. The mode of appointment, 70-71, we don't have any problem with the mode of appointment. If you look at the messy transitions, we thought this had been resolved with the Thomas Donko issue. However, what we realized is that if you look under 190 up to 199, public services, even though appointments are there, termination is not. You have to go to 297, which is the implied power, to have termination. So we, in our proposal, was saying that this review should actually insert a termination and give clarity as to how this termination should be done. Even if you look at that implied power, the implied power says that, you see, the same way someone is appointed is the same way that the person should be, appointment will be terminated. So with that implied, it's assumed that the president who is appointing will terminate, but on the advice of the board given in consultation with the Public Services Committee. That is not done. Then that comes to the effect of the green letter. If the green letter is enough to terminate someone's appointment, why is it necessary then, when a green letter is given for appointment, there is the need to process it? So it means that there is a disconnect there. If it is not enough to appoint conclusively, it should not be enough to terminate as per the implied power. So this is our view with respect to the messy transition. So when we discussed this, we said it goes to the core of also the presidential powers. Because if you take out the universities, which is the 1953, universities, research, and the academia, research and the professional training bodies, where the councils will make. Everybody is supposed to be appointed by the president. And it is such that 195, the effect of 195 is that from a laborer to the CEO, appointments are to be made by the president. So what the Public Services Commission did was that together, this was done together with the executive, we came to an understanding that from the director up, which is the senior public officers, the appointments will come through the Public Services Commission and the appointment made by His Excellency the President. However, below the director, we call it, he is the president. C, D, and E will be by the boards, not the CEOs, by the boards, appointment by the boards, with us represented on the panel to ensure that there is. So this is what is happening. But the challenge we have with this moving forward with these appointments is that, the president appoints, if you take, we said 200, this thing, and you have not less than roughly about 2. So there are almost 600 directors. So you get up to not less than 4,000 appointments within the public service from direct up that the president makes. Senior executive. No executive will relinquish that power. That is why we said we don't want any fight. And we did not go in. That goes to the core of the presidential, but that is where you would have to actually look at that. But that is something we said, that is why we were proposing that there is always the prior approval. In termination, there is also a consultation. That one we could not say prior approval because the person has already been. But before the president terminates, the board and public services should be consulted. So that is a lower, not the prior approval. Termination should be consultation. And that will address the messy transitions that we have. Because currently, public servants, public service, there are certain times when they get to directorship, they don't want to move up. Because if you take currently and what was done previously, all governments, it comes in and the letter is very, very simple. Your appointment has been terminated with immediate effect. These are public servants who have served for, let's say, 20 years, 30 years. Some have 5 years to go, 4 years. It does not talk about anything. And we know that termination without your entitlements is effectively a dismissal. Dismissal is termination without any. Then you have actual termination, which is with some form of benefits. But when it is, all of them now floods to us. They were coming to us that we are public servants. Our appointments have been terminated. What do we do? Unfortunately, we could not offer any advice because we did not know in the mind of but we booked an appointment to see His Excellency the President. We did not know the mind of the termination. It could have gone in simply that proceed to collect your entitlements and other things. These would have cured all what we talk about, the messy transitions. The other thing that has come up also is this termination based on a date. We want most people to understand that the appointments is a process that starts. We have, I think, a 6-stage process, and it takes not less than between 3 months to 6 months in the public service to make an appointment. Nana is agreeing with. So where it is not done, it can definitely be seen from the, from documentation. So we can actually see who has not followed the process and who has actually followed the process. So that deals with the messy it should be tightened. And once we look at appointments and terminations, I think that will be the robustness of the Public Services Commission. I have... Yes, sir. I'm almost done. That's the last thing. Is that all the constitutions envisages a very, very strong public services. But unfortunately, the wording. It is left under Article 196, which says that we should develop standards and regulations to guide our operation. So it is in the standards and this thing that we have set all this out. And the last one, sir, is important. Just give me 1 minute. Is public service and party politics. That has to be addressed within the Constitution because of the nature of the nature of appointments that are made. Most people come in and they are not able to distinguish the fact that between the fact that they are public service who are not supposed to be, actively engaged in party and, political appointments. So we need to be able to address that. Otherwise, transitions will always kick people out because they come in with an appendage of party, go to the media with an appendage of party, and therefore when there's a change in government, you would go. These are the situation. Thank you very much for giving us the opportunity. Thank you.
Thank you. Thank you very, very much. This has been very enlightening, really provided new and additional perspectives and information that I think those of us on this side of the table did not have the benefit of until this morning. So it's extremely useful insight, exactly why we do this process of engaging targeted stakeholders. These are the insiders who work the Constitution, who have intimate familiarity with the practice, and whose views are expected to be different and exceptional from the general public. So thank you very much for the value that you have added to this conversation. I have a number of questions, but I will start with my colleagues from Goodwin. Goodwin will go this way. If you have any questions to ask, you don't have to have any question. I have plenty.
I don't have too many questions for you, sir, but just to pick your mind on the recommendation that the chair of the Public Services Commission should retire at the age of 70 and the vice to retire at the age of 65. What is your take on this matter? Is it something we should look closely at, or we should remain where we are? Then I get from your presentation that you've spoken about the commission from a point of weakness. That's all from a point of weakness. In other words,
it was from a point of strength.
I think from the point of weakness, because although you are empowered, you seem to be rendered powerless by the politics of the day. And I'm wondering from your experience, what do you think can be done to strengthen your arm in this respect? Mr. Chair, these are my two questions.
Thank you very much, Mr. Chair, and thank you very much, Professor. I've also two brief questions. Yesterday, one of the concerns had to do with the incessant establishment of boards, agencies, and so on by different executives for various reasons. They all have their different rationale. How does that impinge on the work and the functions of the Public Services Commission? You've spoken about appointments and terminations and their challenges. How does the multiplication of agencies and so on also impinge on your agency? The second point is also yesterday there was a suggestion about a body to sort of sanitize or standardize, if I may put it that way, emoluments within the public service broadly. What's your take on that? I mean, because that also could generate a lot of challenges and controversy.
Thank you for your presentations. I don't have much to say, but I'm curious why it takes up to 6 months just to recruit someone into the public service. What explains that?
All right. So for this round of questions, I have about maybe 3 or 4. So it's, I mean, given the same constitution, right? Given the same text, let me say, given the same text, I suppose that some other jurisdiction applying the same text would come to a different kind of practice than we have evolved, which is to say that the text alone doesn't appear to be the culprit here. Something, because when I look at the language, it is not dissimilar from some other maybe common law jurisdictions that have a public service commission that is supposed to be in charge of the human resource function in the public services standard setting and all of that. And that has this kind of a relationship with the president, right? But notwithstanding this same text, we have ended up in a situation where even though you have to do this on the advice of the board in consultation with the Public Services Commission, it has become basically a unilateral power of the president, right? Because as I read it, the appointment power appears to me to be a composite power that has 3 parts, right? So there is a certain process written into the language. You consult, you seek advice, then you appoint. But in practice, it's become all rolled into one. Now, you are proposing a refinement in the language that I think is helpful, right? So if you said prior, if you said the president appoints upon the prior advice or prior consultation, then that does indicate some sequence so that this has to happen. And maybe in a country where where words can lead to all kinds of ambiguity, and maybe we need that kind of clarity. So I think it's a helpful recommendation. But will it cure the problem, right? Will that alone, will that grammatical kind of twist cure this problem if it is deeply embedded in a certain tradition and culture of the public services? Because sometimes you put language there, but the practice will undo it. And I'm a bit surprised to hear you say that the mode of appointment of the commission and its composition is not problematic, right? That this almost ceding of the power that you have to the president by practice has nothing to do with how the commission itself is composed or appointed, right? So I would have thought that maybe the mode of appointment has something to do with the inability of the commission to hold on to the power that it has in the text. And you're saying, well, even though, for example, let's say Article 191B, a member of the public services shall not be dismissed or removed from office or reduced in rank without just cause. So this is, termination has to be for cause, right? And yet you say, well, sometimes they get a letter and they are terminated and they come to us and we don't know what to do, right? But it's saying just cause. Right? So I mean, this sense of powerlessness and helplessness on the part of the commission is what I'm trying to get at, and whether or not just mere change in text will cure this, or if there is a deeper problem that we need to look at. Because when I look at the, so for example, you said is the appointment power, and yesterday we did get into some of that, because the way 196 is worded, or as practiced by us, it does indeed imply that almost anybody from Liberal to the chief is subject to the president's appointment power. And indeed, even though in the past it wasn't, the president did not move in that direction, I think with party politics and pressure for protocol appointment and all of those things, we are seeing presidents going deeper and deeper into the bowels of the organization and appointing persons in the lower echelons of the organization. And they'll tell you this is where the power comes from. So I also looked at Article 195.3, which says the power to appoint persons to hold or act in an office in a body of higher education, research, or professional training shall vest in the council or governing body of that institution or body. And is that a useful, is that an additional, would you rather have this kind of a provision be the norm as opposed to the exception, right? Because it appears to apply only to educational, higher educational bodies, where maybe we think it's for academic freedom purposes, we've shielded it. But if indeed the president is not going there to appoint lecturers and laborers and stuff like that because of this provision, maybe that's what you need, right? You need something like that. You need more of the 195.3 than 195.1, right, to be the norm in the public services so that we don't experience the same thing there. So in terms of your proposals for us to look at how we can tighten the language, is this something that you would consider? Have you looked at other comparative models, especially other Commonwealth or common law countries, and how their civil service operates within the constitutional framework that you think works better that we could look at? A lot of the conversation yesterday looked at Kenya, for example, which has a more recent constitution from 2010, widely considered to be more progressive and more, developmentally oriented. And reference has been made by many different people to some of the text in that constitution and how that could guide us. Because things that we are suffering, having difficulties with, like the word advice, right? The Kenyans use the word recommendation, and yet the president is bound by the recommendation, right? So it's the practice, it's how we understand it, because in Kenya, there's a distinction implicitly made between the power of the president to appoint and the duty of the president to appoint. Shall, not every shall is a power. Some shalls are duties, right? So sometimes you don't have a choice but to appoint, right? So in Kenya, when the Judicial Service Commission has done the interviews for the CJ or the deputy CJ, and they've sent the nomination, the recommendation to the president, he cannot refuse to appoint. Right? That is how they have understood theirs. We would have a different understanding of it, right? So the language indeed does matter. So I think it's helpful if we could tighten that issue. One thing that came up yesterday that you haven't addressed is this proliferation of services, right? The Constitution talks about the civil service, and then it goes to define it in the definitions under 296, Article 295. Civil service includes service in both central and local governments, right? But yet we have a local government service, notwithstanding this provision, right? We have a local government service that has been carved out of the civil service. And yesterday we heard about how different groups carve out the legal service has been carved out, and to the extent that there is an incentive to carve out, we can expect more pressure for this carving out to take place. So if you carve out the legal service, and that means that they are going to get their pay linked to the judges, then there will be pressure to carve them out. If the police and the security services and immigration want to have, Article 71 treatment or retire on salary, and they will carve themselves out. How are we going to stop this process? First of all, what does it do to the public service if you're doing standard setting, harmonizing standard setting across the board, and yet you are getting these carve-outs by these different services? What's the impact on the quality and capacity of the public services? And then what might we do to rein in this tendency so that it doesn't, you don't have, you basically have nothing in the end, right, that you can deal with. And then my last question is, it doesn't fall, it was interesting to hear you say that SIGA itself, the SIGA itself is part of, because it's a regulatory, okay, so SIGA is part of 195, but the SIGA entities like Cocoa Board and others are not part of the organization. I mean, that's an interesting, in the 1979 Constitution, there was reference to a public corporation service that I'm not sure was ever formed. But it was supposed to take care of the commercial entities. So that would be like the SIGA or the State Enterprises Commission. If we want to roll in the state enterprises into the constitutional framework, what would be in your view, what would be the appropriate framework? Could you suggest a way for doing that so that we can also have, on the side of the SOEs, a body like the PSC that takes care of these human resource management issues as well as all of the other things that you do in the Public Services Commission? Thank you. Any questions from, we can take one round of questions from the other participants and then you can address them and we can go back. Yeah.
Hi, so thank you very much. This is a question in relation to what the chairman raised in Article 195, because I'm quite particular about it. And I want to find out if you are giving a recommendation or you can give a recommendation in terms of whether we should take out the whole of Article 195 or, because it looks like it contradicts. So Article 1951 looks like it contradicts with 1953. It doesn't. No, it does. To me, it does, because unless you're saying that researchers or the academia side don't come under the public services.
I will explain.
Okay, so that's it. So what I wanted to find out is, it looks like when they were drafting the 92, the academians were in the room because they kind of carved themselves out in that. And that's why I feel it's contradicting 191, because on one hand it says the Constitution vests the power in the President for all public services. And then 1953 then goes around to say, well, the governing body of each institution will appoint the researchers and the academians, basically. So in terms of going forward with the Constitution review, my question is, should we take out the whole of 195 as a whole, or should we also specify in terms of from certain positions, should the president then get involved in the appointments? And as you said, for like 196 laborers, what has the president got to do in terms of the appointment? Should we specify those roles that you wish the president to get involved in terms of the appointment or not, just like how it's done in 1953, because I think that was very explicit in terms of we've taken the president out of academia side in terms of the appointments of it, which is more on meritorious grounds rather than appointments. Thank you.
Yes. On the same tangent, if you look at 1952, it provides that the president may, subject to such conditions as he may think fit, delegate some of his functions under this article by directions in writing to the governing council concerned or to a committee of the council or to any member of that governing council or to any public officer. This one expects that the president must write and direct. So if he hasn't written, that power remains with him. Are you looking at an amendment to this section so that we state what he should do and when he should delegate? Because if we all claim that he has too many powers and 195 is too broad, those who did 1952 clearly had in mind that it should have that ability to delegate. But instead of saying that from this point going, chief directors or so and so, he should deal with that. And then, like my sister said, for the lower group, the board can deal with. They didn't say so. They said he should write. So it amounts to exercising a discretion. He decides to exercise that discretion or not. So can we bind him in this constitution? Thank you.
Thank you. Our former AG has taken the words out of wind out of myself. But I have one more thing. I think I need to know from you, what do you think is the fundamental reason why politics continues to sidestep you as a commission? I've been on government boards and I've seen your work. We've been trained by you. Effectively, you're just a machine. Anything that's just thrown in it, for the most part, will just have to come out. The Constitution and our Supreme Courts have also not done as good by trying to define properly what advice and consultation means. So even if you want to do prior consultation, it doesn't cure your problem. It's another waste of time. We have to be clear why we have the problem and what exactly we want to achieve in principle. Then we look at how we shape this. A few things come to mind. One, the power to appoint and manage the human resource of the public service is a very critical power in the ability of a given political institution to deliver on its commitments. You need people. People want a certain sense, or politicians want a certain sense of loyalty, not to the state, let's be honest about it here, but foremostly to their political interest before the state. So they want that certainty. That's why people don't really want to work with people they just believe are competent. They want to see if the people are loyal to themselves or to their particular parties. So it starts with the commission. The way the commission itself is appointed creates a structure of mistrust subject to who appoints the commission. So if we don't deal with that, to make sure that politically the commission is inclusive and above the politics and insulated from it, we'll have a problem. If the president would practically have to appoint the commission in consultation with the Council of State also, which the president has another way of dominating anyway, why should we really trust the independence of the commission when I did not really appoint you? It's the same problem we are finding with the NDPC. It will continue to be a lame duck. So while you are addressing this, I think we should deal with the fundamental problem. There's a trust problem between the executive and a critical independent organization as the commission. How do we cure that? I would propose a few things for us to just all think through. If the commission, for it to have that independence, is actually perceived to be fully professional and jointly owned by the politics, may mitigate that. How could that be achieved? If it wasn't just the president who had to really appoint the entire commission, but we're going to have an objective process, maybe coordinated by the presidency, and Parliament would have to approve by some 2/3 majority, which in most cases will require both the opposition and then the ruling government. At the end of the day, you're likely going to have a very objective appointment in there because you need to achieve proper consensus. Will that help mitigate the suspicion and the mistrust? If NDC and MPP all get actively involved in who sits at the commission, then we can all trust the commission. Then we can empower the commission to be able to deliver the HR needs that can translate policy into actual impact as far as the people, the citizenry is concerned. So these are the thoughts. I'd like your perspective on it.
Thank you, Mr. Chair. I think this issue, rightly just said, came yesterday about getting PSC to go through a process through Parliament, then President will appoint. So I think that's about the same thing, what your thoughts are. Because of the independence, consensus, and then the ability to continue, so that the issue of mistrust. Indeed, analysis was done of the last 2 or 3 chairpersons of the PSC and the implications for structure, for performance, for all that. So that issue is very critical.
May I give you one last one before you go? The green letter business, right? So this green letter, of course, it's published, right? It's not like the president sends you a green letter and says, this person has been nominated, so do your process this person for appointment. And then once you are done, the white letter comes. Unfortunately, the green letter is announced publicly, which of course then undermines your work completely, because the moment the nomination is made public, then basically I see how it is almost impossible for you, given the culture in which we operate, for you to come and say, well, you've done your nomination, but this is our advice, right? So if the green letter was not public, was not made public, would that change anything?
Now, looking at Article 197, the Public Services Commission may, subject to the approval of the President, make regulations by constitutional instrument for the effective and efficient performance of its functions under this Constitution or any other law. What do you think of with the approval of the President? Yeah. Why should it be with the approval of the President? If you are an independent body and you are looking at how to have an effective and efficient performance, and they are saying whatever you do should be with the approval of the President, is it not giving you something with one hand and taking it with the other? Because whatever you propose must have to go and lie on the desk of the President, and his people around him would depending upon which way the wind is blowing, would either say we agree or don't agree. So this section, or this article, should it remain? Thank you.
I think that's an important point, because if you consider the other independent bodies, you would not find, I mean, they can make constitutional instruments without, let's say, getting the approval of the President. So if the EC or NCC or SHRAJ can empowered to make regulations by constitutional instrument, but don't have to go through this subject to the approval. Why must you if you are an independent body, right? So I think it's a very important contribution.
Good. Thank you, chair and members. I think they are incisive questions. I've written 16 of these questions. So, another that I don't do all the talking. If there are any issues that you want to look at, you can. Now, the first question was the appointment of the members of the commission, and does that create challenges with the independence and that? I would want us to look at the category of independent who go to parliament for, parliament's, let me say, approval. That is the Chief Justice and the Supreme Court. However, after going through an approval by Parliament, they are still accused of, being biased and partisan. So you cannot, depending on who appointed them. So, no, that I'm coming in to the idea that, the most important thing that we need to address in the country is not who appoints, but have you given that body sufficient powers and authority to perform their functions without executive or any other overreach? That is what we should be thinking about. Otherwise, you can get the 2/3 majority and still the body or the people, once they are appointed, will not have the powers to actually perform their functions. So I'm not doubting the way, but I'm saying that instead of looking at just the way in which the commission is appointed, and the commission is equivalent to, the chairman is equivalent to the Court of Appeal, vice to High Court. So it's assumed that it is the same or similar process through that, and you have that. So, yes, we can modify, but I don't think that is the only solution. Moving forward, we rather need to strengthen and ensure that the functions are done. Then, did I speak from a position of weakness and not the strength? I was giving you, when we met, and our experiences, what the practice is different, just as the chairman said. What is in the text is different from the practice. We need to be able to strengthen it. Otherwise, let me give you a typical example. Even this 1953 might not work. In the previous KNUST, there was a problem, and there was an executive decision to dissolve the board. The vice chancellor should stay out, and this is a minister's decision, even though the constitution says and we were not even consulted in the process. It was a minister who said that there was a problem on campus, therefore it's an emergency, and he took that decision. So just getting even the 1953 wording might not necessarily solve the problem. And someone jokingly informed me that, you see, the reason why the executive is not really interested in the universities is that the situation is changing now. First, the universities did not have any resources. It is not, it didn't used to be a major, Vice said, a major, is an asset, but I don't want to give this thing, but that is why people leave them. It's a university, let them handle that. The question is, I agree with you, we could go for the 1953, but I'm saying that beyond just the word, we need to couch it such that we would have a strong PSC. Then, establishment of boards, this proliferation. And I think that is actually important. Even though in 196, we are given this thing, that we are not even consulted when it comes to creation of new public service institutions, or whether one is changed from a board to an authority. We are not. It's just an executive and it goes to Parliament. So we are trying to amend our act to ensure that these will be consulted in that. What is even more worrying is not only this. It has to do with issues that governments come in and create programs. School feeding is not really an agency. It is a program, but now they have divisions throughout the country. They are employing. On what basis are they employing? Are the people public servants, or they are just programs? NEIP and all others. These are the challenge that we have. Proliferation of this thing. It starts as programs and it ends up as perpetual agencies without acts of parliament, but still in the statute books. Because there are so many that you cannot actually do away with them at any particular time. These are the challenges that we have. We are an agency to do that, but because of the way in which it is done, is the consultation that we're looking at. And these are some of the issues that, when it comes to the incessant establishment of boards. And then recently there's what we term cannibalization of the civil service. Because we're there and then, this is out, but the those in foreign, this thing said they are in foreign service, they want to move from the Public Services Commission into a foreign service. Because, as the chairman rightly, being a service comes up with certain special privileges. So these are the things that we were supposed to actually address. The public service. You need a very strong agency to be able to do that and harmonize the issue. And that comes to the second that the chairman raised. Do we need a separate public service? That is the Kenyan model. But then you would find out that in the end, when you have two bodies, the standards are not the same. So the question I would look at is, do we continue, that's what this thing, do we continue to have these centralized management agencies, but with the same standards and rules pertaining? Because once SIGA is, GTEC will now say, we want also to have, a commission, educational commission. And in Kenya, they have 6 commissions.
So if I understand you properly, on the SIGA question, you would bring the state's commercial entities into chapter 13, right? 14.
Yes.
But you will have one public service commission, SIGA and the Public Services Commission, like all the other ones.
Yes.
Office of Head of Civil, all of that.
Yes.
But SIGA just is one of them. And okay, so as opposed to setting up a separate, but I thought that the idea, the logic of taking the commercial out of the public services was that there was something in their being commercial in nature that made their human resource management somewhat different. And that if you were not a regulatory body, if you were not doing implementation of executive decisions or policy, you could be in a different category. But that once you are in business making money and making profits, we should not subject you to the same human resource regime as we would the public service, which is the case for a separate SIGA-like or State Enterprise Commission-like body.
Chairman, I agree with you. However, it's the same way. The practice is not the same as the text. In the SIGA Act, you find out that there are three things. The first of all, there is the state, state enterprises, state-owned enterprises. Then there's the JVCs. And then there is the other thing, which is creating all the problems, called other state entities. The SOEs are 46, 56. Thank you very much. Those are the ECG and all others. Then there is the JVC. They are 70 or 75. And then you have what they call the other state entities, which is the Public Service Institution, Forestry Commission, Foods and Drugs Authority. They've all been roped in and saying that SIGAs, so there is some form of overlap that because those are raising revenue, SIGA should have oversight. So that is the challenge that we have when you have that. How do you define what state interest is? And here, state interest is defined as revenue. But even then, you should not have any problem because what we do is an organizational oversight. So that is something you need also to look at when it's. So it is not just the commercial as is the 190. It's been expanded to other state entities. And they are even more than, currently, how many are they? 175, which is more than the SOEs and the JVCs. So in actual fact, it is almost 80% of the public services agencies, which are now part of the SIGA oversight.
So state entities, the term interest doesn't mean equity. It doesn't mean state shareholding or ownership interest. It just means you make money.
It's been expanded to any entity that makes
charges a fee, makes money.
Yes, and therefore that is the state interest. That is the challenge that you have with that. That's why I said it's easier to put everything under, public services and then have these. In that case, it's a very easy and neater in our view.
But alternatively, you could say that if you took all of these commissions, the regulatory commissions, whether or not they make money, you took them out of SIGA and put those appropriately under Public Service Commission, then you could leave SIGA to just deal with the entities where the state has equity interest.
That is the current constitution. That is what the current constitution envisages.
That's right. But
yes.
It's been modified in practice.
It's been modified in practice, yes. Yeah. So now I think, fourth.
I think Professor Kakai's question was different, right?
Yes.
I think yesterday we had a conversation around governing councils because the Constitution somehow appears to require that you have a governing council for every service. And part of the conversation yesterday was, do we need governing councils for every public institution? Do we need a governing council for, say, Office of Special Prosecutor? Do we need a governing council for Auditor General? Do we need a governing council? So we set up a board for almost everything we create. And I think that was his question, was not about the proliferation of agencies as such, but about boards all over the place.
Yeah, thank you very much. I would address that. It's because of the nature of the 195(1), which says that all appointments have to be by the boards given in consultation. So the assumption is that there is a board. But actually, in practice, we can do away with a lot. Because if you take the office, the head of the civil service, there's a civil service council that looks after all the 25. There is a local government council that looks at that. But if you get to the tertiary, then every university has its council because of the 195 3, because every entity is the council that has to appoint. So in looking at that, we need to be able to look at the 195, which is the basis of the for the creation of the boards. Because if they are to make the appointments, they are to help in terminating, then for each agency, you need that body. If we are to do away with it, then the only way will be the sectoral approach, where you'd have for each sector a board, just like you have the council for that. And that could be done.
Or, I mean, it's so, in terms of criteria, if we're looking for a criteria to determine which public institutions, for which public institutions is a board appropriate, and for which ones a board is really not appropriate. I mean, could you help us with some criteria? It doesn't have to be a spontaneous response, but if you could supplement your submission and help us with some criteria to determine which public agencies should we have a board for, and which ones really we can do without a board, because it's also a huge cost on the state. You have to appoint all these boards, pay them, you know, when in fact, I wonder, for example, what does the OSP board do? Does the special prosecutor go to the board and say, I want to investigate this case? Of course, that's not what is happening, right? But so what exactly is their value addition? What does the Audit Service Board do? And what does the Office of Head of, the Governing Council of the Civil Service really do? Right? So maybe some boards, if you ask me, state-owned enterprises, yeah, you need a board to appoint a CEO, to look at, you know, to do what directors do in normal private companies, to, you know, make sure that the fiduciary obligations and shareholder, everything is done. But many of these state enterprises, you are there, public service is there, all these, why do we need a board for every one of them?
Thank you, sir. I think anytime you can come in, it seems as if but so what you need to do before we can proffer such is to actually do a mapping. Because, for example, for us, FDA and Ghana Standards Authority, they are certain, overlapping functions. They are all standards setting and over regulatory bodies. So we can put a lot of the regulatory bodies under which perform this thing. But it needs a careful thought out. It's the same with issues under, culture, tourism, and all those under. It would have been very good to put them all under this thing. But as I said, we need to sit down and actually map out before we can get these issues, these done. So that is mine to that. Then why does it take up to 6 months to make an appointment? We have, as I indicated, you have about 6 steps, as it is in our standards. First of all, the boards will first identify the vacancies. And you see, the vacancies should be in line with what we call the establishment levels. Because each institution, for example, Deputy Chief Executive 1, Directors 4, this 10, it goes down. So before we can even give someone a technical clearance, we need to know that the position that they are going to appoint, there is a vacancy for that position. A lot of times you would know, I wouldn't mention some institutions, but a chief executive comes and all the people who have been appointed are sidelined, goes in and makes acting appointments. After 1 year, submits those who are acting during his tenure to the public services, to interview. If you don't, so what we say is that there should be an internal advertisement. Show us the proof that all the people have the opportunity to apply. So if indeed some people have been sidelined, they would have applied. Then we look at it, and before we now even give you what we term the technical clearance for appointment. After the technical clearance, you are supposed to go to the Ministry of Finance for financial clearance. It is after you've got the financial clearance that you can now even set up a committee to interview the people you have short-listed. Or if it is the director and above, it is then that you are referring to Public Services Commission to look at that. After, when the ones that come to public services, once we've interviewed, we now prepare what we call a transmitter letter, an advice paper to the board. The board has to discuss that these are the people you presented, because it comes, we do not interview anybody, it's from the board. The board now comes in, they accept it, and then it goes. So this is the problem why you have...
May I just a quick interruption? So this process that you are outlining, is it in a constitutional instrument? So for example, I mean, the Honorable Ayikwe mentioned Article 197. You are describing to us, how you operate, the mechanics of how you do something, which of course is probably too much detail for a constitution. But is this the kind of stuff we would find in a CI that has been enacted by the Public Service Commission? Is it something in subsidiary legislation that...
It is what we term, and that's we accept when there are challenges. What we have is a human resource policy, and...
so it's not been translated into a CI?
It is there, which will be translated into a CI. So all this are... Oh, sorry. There is, and that is where the 197 and 197 comes in, that we are supposed to develop standards, and that's 196.
No, 197 says you may make regulations for the effective and efficient performance of your functions, subject to the approval of the president.
So that is what has been done, and this is what we are quoting from the regulations.
Okay.
And that is why we say, as part of the regulations, the president then appoints from director and above. Below director is the board.
So this is the proposal you are making?
No, it's currently in the... It's currently in the... So all that we've said...
is in the CI?
Is in the... It's not a CI, it is in the standards.
Well, but if it's not a CI, well, that's the problem, right? So the legal...
Yes.
I mean, 917 gives you the power to make regulations by CI. But if you have it in a policy document, that's not binding on the president as such, right? I mean...
I agree with you. The challenge, as we said, is what is in, that you need the president's approval.
But what, have you sought it and have you tried to get a CI through and it's been denied, or?
There was a draft some time ago, but it's not gone through the...
Sure. It's accepted. But if you have a Trump and who comes and says, this is not in any law, I'm not bound by this, I'll do it my own way, which is because also in the past, presidents didn't used to appoint laborers or PROs or whatever. But if you don't have it in a law, then the president will come and say, fine, this is nice convention by my predecessors, but it is not hard law. It doesn't bind me, and so I think PROs must be appointed by the president, or I think, deputy assistant PROs must be appointed by the president, and I proceed to do that, right? So there's a room for hard law, and then there's a room for convention and practice.
Agree with you, Chair. I think 6, 7 are the same. Text alone does not appear to be the challenge. It's the practice. And we agree with you because the text, if you look at all the preambles, as I indicated, they said, oh, public services is supposed to be the controlling body. We need to empower the Public Services Commission to do that function. But you find out that the text alone is not enough to the executive is powerful. That's the basic thing about that.
Even though the executive is not here, you seem hesitant to say it.
Oh,
even that fact is.
That's why when we said, if you look at all the constitutional, they have bodies in the past, especially the 2012 or
2011.
You know, there was the chapter, a whole list of things that came out. But in the end, virtually none of the recommendations were. And there was one that they talked about, the presidency should not make certain appointments. That did not, the white paper did not. That is why I said in the past that, oh, we know that, but we were hesitant to put that in because the previous were not really accepted. Maybe it's our fault because the current president is resetting, so
I mean,
he will.
The point about politics has been made. So if it's not the mode of appointment, if you don't think it's the mode of appointment, to the extent that the public services remain an arena for party politics in terms of places where you can put people, which has been the problem since, the beginning of time, right? 1960, 50, wherever. To the extent that that remains true, and we have the kind of job market problem we have and all of that, and party politics we have, what would you do about the politics? How do we take out, not exactly take out, but mitigate, minimize, moderate the infiltration of politics into the public services, at least on the human resource side? Because as long as it remains the case that there are all these opportunities a president has to satisfy foot soldiers who campaign for them and all of that, it's very difficult, to expect that a president would not take advantage of those opportunities, right? Because that's the politics we're in. So one of the challenges we face also on the committee is, how do we minimize these opportunities for politics to enter the public service so that you can have some breathing room to do your work, right? How would you propose we attack that problem?
Yeah, thank you. And the very first thing is that, like the public, which article that lists the institution, I think there are 11 that states that, no, not 190, under the executive and 40 or something, sorry, I will have it, where it states that the police service, the civil service, and others are not supposed to do politics.
This is the provision listing the eligibility to be MP.
Yes.
And so there are certain people, yes, that's okay.
So you find out that that is why currently the civil service, they are on, strike because they believe, please, what, if you can remind, no, it's in the 40s. The chairman got it. It's eligibility.
It's 90, Article 90.
Is it?
94, 3B.
All right.
A person shall not be eligible to be a member of parliament if he, B, is a member of the police service, the prison service, the armed forces, the judicial service, the legal service, the civil service, the audit service, the parliamentary service. So this essentially means that you can't do politics But it's only limited to campaigning to get into parliament.
Yes. So that is where we need to make all the public.
Oh, there's also 43B. This I'm reading from 94, 3B. Yeah, 3B is
yeah, that's what he. So I agree perfectly. What we want is that the provision should not be for party politics. For public services, we rather quote the 284. The 284 talks about conflict of interest. And we always send our circulars to public servants that for conflict of interest, you cannot go into party politics.
But you have to be very specific that that conflict of interest applies to party politics.
Yes, that's what we do.
Okay. So for constitutional review purposes, would you propose? So what you're saying is that contesting elections is not enough, right? One, it should apply to all the public services, not just list a few.
Yes, please.
But what you're saying is that, if I understand you, you are reading the prohibition against conflict of interest to include not manifesting or demonstrating party politics while you are on the job.
Yes.
So we know public servants do go to campaigns and wear party T-shirts. And so you are saying we should do it?
Yes, that is for the public services.
For the public services.
Once someone is coming in and he knows that I'm not supposed to do that, I think that in itself will help address.
In addition to prohibition of participating in.
Because
but hasn't the Supreme Court also ruled that some public servants can go and campaign and come back?
Yeah, that is based on this, the 93B, because that lists that. And so all other public services are not listed.
Okay, so
and therefore, currently, per the Constitution, any public servant
that is
not listed here
can go and try and come back.
And that is why we use the 284 to restrain that you can't be a chief executive, go out and campaign against the minister and government, and come in again as an advisor to the same person that you have campaigned against. So that is a conflict of interest situation, but it is not.
It's not specific.
It's not specific.
Yeah, you are interpreting it very cleverly.
It is in our standards, as Nana said, agreed by everybody, but the legal thing on which it stands is quite weak.
Fantastic.
Yeah, so if we can get everybody specifically, all the public service, not only linked to Parliament, but before we term it, before you take any active step, active step, that should be defined. And once we define active step as, they say, primaries, then it means that it's not only Parliament, but you cannot stand on primary. But as for people airing their views in the office and others, you cannot really.
Why not? I mean, if you in many public, yes, you can. You as a voter, you have. I mean, you have the right to vote for. You have a party preference, but if you openly manifest party affiliation on your job as a public servant, don't you create a problem? I mean, don't you create an atmosphere where that is not conducive to the work that you are supposed to perform? So if that happens and the next government comes of a different party and they want to go against you, it becomes difficult to protect you because you are, you play party politics and all of that. So maybe it's possible to do that. I think it's not. I understand your concern. There's a balance between your freedom of speech and your right to express yourself, and being a public servant doesn't mean you have to lose all your rights, but we have to find a balance. Maybe it would be good if you could propose something that works.
We will.
Thank you, Mr. Chair. Just to add a bit to that part of it, because you had earlier asked about, how we can mitigate, politics in the public service. I think one of the areas that we also identified has to do with the mode of termination today, because that in itself lends itself to people in the public, offices, either seen or practicing, real politics in the course of their actions. And I think because in the Constitution, if you look at 191B, for instance, when it talks about protection of public officers, and it just talks about just cause. But this just cause is not defined, it's not itemized, and therefore people would want to, in quote, protect, as it were, themselves by engaging in active politics, as against knowing that you are a public servant, a professional, and for that reason, you have the job unless there is a listed just cause that you would have, been defiant of. So one of the submissions that we made in our paper to the CRC is to ensure, to say that, we would want to recommend that the PSA is giving the mandate to actually have a CI that itemizes the just cause, by which we will have the opportunity to make recommendations to the presidency, and therefore if a termination is not following a process or is not as a result of a just cause, then we could have cause to say this is not in line with, because we believe that when the just cause is specified and itemized, and public officers know that as a professional, I don't need to engage in X, I don't need to engage in Y, because those will be just cause for my termination. I think it also mitigates this whole issue of, politics mixed with professionalism and in the public service. Thank you.
Two quick ones. The 195.
I advise that we are long past. I think the conversation is exciting. Yes. So we've been talking. We usually break at 11 for a coffee break, but I think we've it's been very engaging. So we've gone over time. It's almost noon. Can we take a last point and then maybe have a break for about 10 minutes?
Just a quick this thing. The 195, 1 and 3. It's good that the chairman also knows about the ladies. This thing is, do we really even need the 195 because of the university and all other systems? And then I'll take that together with 195.2. In 195.1, because that is my our understanding, because of the broad nature that from the laborer to this, then 195.2 made room to engage the presidency for you to outline. It's more like delegation of some of the duties, but the delegation should be written, either in a form of standards. Once we engage, there should be that. But 195.3 is actually entirely a different, we term, cup of tea. The universities are created for independence and for freedom. So in the university, someone will be in the classroom and can, as part of those who do political science, will criticize, government's decisions and policies. And if you, under 195, quite frankly, you are supposed to advise government or public servants. So you can't, as a public servant, go on radio and speak against, technically, government policy, because we have ways in which you can advise government. But in the university and research setting, it's an unfettered this thing. So they needed to be protected against all these things. And that is why 195 comes in, that you have your councils. Let the councils regulate your employment, the things you can do and not do. So technically, you will find out that, for example, those who are in the public services, they might go to parliament and the conditions are different. University, they go and come at any time. You move, you come in. That is an entirely different. So I think 195 needs to stay, except that the text has to be looked at. The models. You know, we started with the UK model. And interestingly, the UK model has even been more, if you look at them, they have tended to more or less even separate from, you know, at that time, when we were starting, they still had some level of oversight over the public and civil service. That's the civil service in UK. Currently, 2 weeks ago, when they wanted to reduce the civil service by 15%, they now have thrown it, government, to civil service, find ways, we don't care, find ways of reducing your budget by 15%. Government says, we are not saying terminate anybody, but you, the Civil Service Council, find ways of doing that. It's the Civil Service Council that will terminate, they appoint, and they, in terms of even salaries, they do it. And that brings me back to the Emoluments Committee. Has gone through a number of things. First, it was the Public Services Commission that determined the salary. So after your appointment, people were recruited in UK, and it was a position-specific this thing. You are recruited in UK, you come in, we discuss with you, and you are given your appointment. So you have two people. One is recruited outside. The appointment conditions would have been different from that. Then, over time, it was indicated that why don't we harmonize things, and therefore fair wages was introduced. But if you look at the text of the Constitution, salaries is still a function of Public Services Commission in the text. So what they had to do was so we jokingly say that there is an act currently which is superseding the Constitution, because the Fair Wages is an act, but, you know, all the provisions in our act that had to do with salaries were taken out. But we agree that you move on. But in terms of that, we need to be...
I think maybe we can come
Thank
back.
you.
Yeah. We can take the quick break. Some people are coffee addicts and they are suffering. So maybe we'll take a break for coffee and we'll come back in 10 minutes. Thank you.
We can
the public services, as we've discovered in this morning's conversation, are legion, as to use the biblical word, legion, but they are also quite interrelated. There appears to be quite a bit of continuity in this conversation and the one that we've had previously, also relating to, say, local government and the public administration and its impact at that level. So we will continue, but I think we would want to devote some time before lunch to looking at the SIGA entities. We haven't fully exhausted the public services bit, but I think there's sufficient overlap, so I'm sure we'll go back and forth and come back on this thing. But it's, looking through the Constitution and even looking through the past reports, it's clear that the commercial entities, by virtue of one small language in Article 14, in Chapter 14, by virtue of that language that says public corporations other than those set up as commercial ventures, this provision, which also occurs in the previous constitution, has been understood to be, and I think that's probably what the intent was, that state-owned enterprises set up for profit are not captured under the public services. So they are in a class all by themselves. For us, we want to find a rationale either for excluding them in the Constitution, from the Constitution, or for bringing them back into the purview of the Constitution. So we would like to devote some time this morning or this afternoon to that discussion. How do we roll into the Constitution the SIGA entities? We've understood from the chair of the Public Services Commission that it is not a straightforward question, that currently SIGA as an authority, as an entity, is itself under the Public Services Authority. However, a good number of the organizations or entities under SIGA fall outside the public services by virtue of Article 191B. And yet there are other SIGA entities like the revenue-raising, fee-charging entities like Forestry Commission and Standards Board and all of those ones that are somehow still technically under public services, even though they are revenue-raising. So it's a whole web of overlapping, diagonal lines crossing here and there. So we will need some time to untangle those and then to digest this matter. I invited, I don't have a presenter as such on this one. I invited persons familiar with the SIGA establishment. Mr. Stephen Asamoah Boateng is here. I think he was the first Director General of SIGA at the founding. So as a founding father of SIGA, I thought it would be appropriate to get him in the room to help us dissect this matter. I also invited others here who I believe have either through their public commentary or their academic work or their other vocations, I know to be very interested in this matter of public state-owned enterprises, and I've looked at it very closely over the years. So they also are in the room, and they can, of course, chime in at any point. So, Asabi, if you don't mind, and Asabi and I go way back to the Legon days, so I can call him Asabi. So Asabi, if you don't mind, I'll put you on the spot and have you give us just some few remarks about this entity, animal called SIGA. I know it has an antecedent in the State Enterprises Commission, and in the 1979 Constitution, there was some sense in the Constitution when you look at the language. Also, it was in Chapter 14, so Article 157, 1 of the 1979 Constitution, it says the public services of Ghana shall include, and it lists a number of them, and public corporations other than those set up as commercial ventures, which shall constitute the public corporation's service. Right? So there was an intent under that Constitution to put all of these commercial ones under a public corporation's service that I don't know ever materialized, in fact, but that was set up in the Constitution. I suppose that SIGA would be the modern sequel to that body that was contemplated. So just can you help us with SIGA versus PSC, SIGA, and how it fits into this whole framework that we are trying to look at? Thank you.
Thank you very much. First of all, let me apologize for not coming in at 10 o'clock when you started it.
This one, I like this one. It's more, can you give him one of these funky ones? I think this one works better.
Oh, okay. This a bit, it's echoes, isn't it? Let me try this one. Yeah, thank you. Thank you, Professor. But I was indisposed and really I'm not supposed to be even out of the house today. If the doctors find out I've left, they'll kill me. But this is so important. And myself and Kwesi go a long way. And when SIGA started, or when we started the idea of getting the State Interest and Governance Authority, I tended to share some few thoughts with yourself briefly. I would have wished to be here when you started the discussion, so I have an angle of what you've said. Rightly so, when you said that the Public Service Commission is saying that there is a bit of complexities there. There is. Indeed, when we started the formulation of SIGA, they were part of the whole idea, Ministry of Finance and other interested parties, other independent people, some directors of some companies, even private sector were invited. We spent a lot of time to do the concept papers and get the whole act put together and to pass it through Parliament. By the way, it's the only act, so far as I know, Act 990, SIGA Act, which was passed twice in 1 week. So you see the attention that came on it. But you are right. It became an amorphous group where we need to define it properly in the Constitution. Although it's an amorphous group, it's very key to our national development in terms of how we manage especially the profit-making state entities. And so I said, I think that constitutional provision must be made where we isolate the profit-making ones out of the public services in a way. But there must be also a link. That's the thing. There must be a link to the Public Services Commission. Because they're all classified under the Public Service Commission, although the public corporations or not for profit or whatever. So there must be a link, but it must be defined clearly as a government attempt to run business. Government is running a business like the Chinese do, like the Russians do, like I think Peru. We took some examples. They have made provisions in their constitution where it is well mandated and it's spelled out what their roles and responsibilities are. And then government then have a way of managing it so that they bring in the revenue. They also bring in the aspect of employment, because that was the original thinking of state-owned enterprises in the First Republican administration. It creates employment. Let's absorb our own, especially the youth who are coming up. But it looks like we've lost it. But two key things: profit making and also employment opportunities. So I would favor the idea that we should have a provision in the Constitution somehow, so it's well defined. We may not be able to exhaust everything here, but we may need to set up a small group within your government. I would then submit some few thoughts in terms of exactly how the clauses can be couched. And then I will submit it to you. I mean, without knowing what you said, it's difficult to go into some more details, but I can say to you that it's become, as I sit here now, looking back, it's almost becoming like the normal state entities we created, and everything goes. It's not distinct anymore. For the past 3 years, I've had cause to complain that when I left, it looks like it's just going back to the normal, and it's become one of those entities that may not even make any sense to all of us. And maybe it's an additional cost to the nation. But if we create it well and we make provisions that tax them to deliver certain things specifically, I think it will be in a good order. Thank you.
So we have the endorsement from the founding father of SIGA to incorporate the profit-making entities into the constitutional framework, and I think that there is very good reason. I haven't seen any or really heard any cogent argument why they should not be included. I mean, the Constitution covers pretty much the governance of the state, generally speaking. So if there is a big part of the state or economy that is not captured, there must be a good reason why that is so. And unless somebody has a good argument why we should keep that outside of the Constitution, I think that the principle of bringing all of them into the Constitution makes sense. Land and natural resources are things of commercial value. They are in the Constitution. The 1979 Constitution indeed contemplated that they would be regulated by a special body called the Public Operations Service. So it's not clear to me why we have not actually done so until now. Maybe there's a reason. I don't know the history why they have been excluded. But I think given the volumes of resources, percentage of our GDP that runs through these very important entities, the case for including them, I think, is a fairly strong one. So, but if anybody knows why they are not an appropriate candidate for inclusion in the Constitution, maybe you can use this forum to explain it. So, my first question, however, going back to some of the comments that were made before you got here, I think the PSC also accepts in principle that we should indeed roll the SIGA entities into the constitutional framework. And you also acknowledge that there has to be some linkage between that and PSC. I know that this is, I'm putting you on the spot. I didn't give you enough time to work this through your mind and reflect on it. And I'm happy that you say you are going to bring us a written submission. That would be very helpful. But I also sense that you don't think that it should be strictly, in terms of the governance framework for SIGA, should we, there's one proposal from one person who has looked at this very well, very closely. The Institute of Directors also have sent a submission they've also looked at it. The one difference in the way they would like to treat the SIGA entities is, if I recall, one of the suggestions is that, well, because there is something about them that is different. I think one proposal, for example, says, they concede the role of the president in the appointment, right? They concede that the president must have a perhaps more substantial role in the appointment than the public services, right? So if we think that the public service is just for public administration, for implementing government policy and laws, and for advising the executive, so we must deal with them, differently. The commercial ones, there's a lot of money that is going there. We must be very careful, with Cocoa Board, with GMPC, and those ones. There's, in at least one of the proposals, an acknowledgement that because of that, even if we are moving, at least intellectually, in the direction of saying that the president's role in the PSC must be minimized, there are those who say, well, when it comes to appointing CEOs of Cocoa Board and those things, we must concede an important role for the president. So one proposal says, for example, the president must be presented with a number of options. All of them are moving in the direction of meritocratic competitive recruitment, right? Open meritocratic competitive recruitment. And the corporate governance system that I'm looking at from the submissions, especially I think the Institute of Directors one, is there's a vacancy, the board advertises, the applications come to the board, they interview, and then they send the president, say, 3 nominees. I think there's also one that says the president must send the board some nominees. So there are these ways in which this is, but there's a certain acknowledgement that the president must have a role, but not unilaterally just appoint. Have you thought through how we might do this if we brought in the SIGA entities, how we might do the corporate governance structure in that sector, how we might bring in the PSC in your thinking? Should we create a new State Enterprises Commission type thing in the Constitution, like the Public Corporations Service under the 79 Constitution, or some other body?
Thank you, Prof. Indeed, I haven't done a lot of the thinking that you've just put across. So it's a new prompting for me to go and look at the details. But indeed, when I was involved in this setup, we acknowledge in a way that they are key to our development, especially you mentioned Cocoa Board, which is like an island to itself. They can collapse the economy if you leave Cocoa Board on its own. GMPC, Ghana Gas, these are huge state entities that, from the way it's organized, if it's not properly managed and authority is taken out, then what's the role of the president? I'm running this country. This is Cocoa Board. It's a huge organization, and I don't have any influence over them. So I'm here sitting there and doing nothing. But on the other hand, too, what I've also noticed, and I had my own challenge with the president on this one, running battles, is the undue influence in appointments, and became like a political appointment. So whether you know how to run a business or you don't, whatever, it's a political appointment. Go there, go here, go there. And even in some instances, and even it's still persistent, that CEOs and boards are appointed with no real understanding of what they're going to do there and who is supervising them. So let me just say that I think we need some detailed work on this thing. President's role must be acknowledged in there. Somehow he cannot be taken out. He or she must not be taken out. But we must define it in a way that he or she doesn't have the automatic right to just do what they like. There must be a process in which appointments are even made, and which are more private sector influenced or led. Indeed, when we were setting up SIGA, the idea was that the mindset is a private sector organization, but with a public services oversight. And we can do that. The Chinese do it. It's a public service oversight, but they run it as private entities. But in our system, it's like private sector, but I still want the public service oversight, but I still want to run it. But you don't have that expertise. And so we need to have the president's influence, but get the private sector. And I like the idea of the IOD, the Institute of Directors, coming in. We worked with them. Who's here from the IOD? Is anybody here from the Institute of Directors? Nobody. Okay. And so I like the idea. President must be given some responsibility, but private sector mindset and private sector processes of running for-profit organizations must be involved. It's a dodgy thing. Presidency in Ghana, I'll come to that if it's part of your today's agenda. The executive powers under the Constitution.
Since we are not going to have you...
it's too overwhelming.
Feel free. Just free.
It's overwhelming. I mean, I've said it on countless occasions that I would have preferred us to adopt the second Republican Constitution or the Westminster type.
You are a British man. We know that.
I know that.
We didn't adopt that.
We've passed that stage. We've passed that stage. So going back is not the option.
Not necessarily.
Well, it can be, because this idea about one person sitting there with all the powers, and when something goes wrong, you cannot really question. They don't even come to Parliament. They don't go anywhere. They issue whatever they want, and they won't explain because that is their prerogative. But yes, you've been given authority to run the country, but as you go along, you are carrying all of us. So we say go here, but as you go, we may have seen something you don't see. We say, all right, turn around, come over, look here. But you don't want to listen till 4 years. Then we go there with the anger, rather than reasoning as to how we elect. It's anger for what you did to me, what you did to us. So it's past that stage. But what we need is to take some of the powers away. Your review committee must look at all the powers of the executives. This is our bane in Ghana. I can tell you that I've seen, I've seen Rawlings a bit, not much because I was in exile. But I've seen Kufo, and I saw Professor Mills in a way, Mahama, first Mahama, and then Akufo-Addo. It's like a standard template. And it doesn't, the people don't matter. It's just one go, one come. And everything remains the same. Because the power is given to them. And so we need to find a way. So SIGA, coming back to SIGA, it's a unique opportunity for us to realize the potential of our for-profit making organizations. That's why we set them up. We cannot set them up, pump money in, then they come back with losses, then we keep feeding them. If that's the mindset, until SIGA came, that's the mindset. You run the losses, we'll bail you out because we cannot afford to let Cocoa Board collapse. So government is forced, hands are forced to go there. So yes, he has to have a responsibility, but we must curb it. I thought that by inserting a minister for SIGA, the person who occupies that space in the presidency would have that private sector mindset and basically giving that responsibility and run SIGA, but obviously in the president's office. So you can then report to the president, but running a private business. But unfortunately, the ministers we've had, I think, 2 ministers.
Yeah.
Kokwe Free and who else? Kokwe Free was my first minister. Then I had Joseph Kujo. And Joseph was even given a ministerial in terms of a public enterprises minister. Somehow, I didn't understand it myself, I can tell you. But Kokwe Free didn't have a portfolio, just a minister in the presidency dealing with SIGA matters. So we need to have that minister. The role for the minister is important because even in the law, unless you change the law, it says a minister. When it refers to a minister, it's not the finance minister. Some people got confused. In all our legal frameworks, everywhere you see minister, sharing financial matters is finance. But SIGA's minister, because SIGA is the shareholder, and Discover is a shareholder of the state shares, The minister there is the minister referred to the SIGA Law Act 990. And so his appointment must be carefully made, not just any minister, carefully made. So president can have authority, but he doesn't take decisions. He's a minister there. And that minister must also be, the role must be defined somewhere so that he doesn't also take it as a political appointment. I don't know whether I'm making sense.
Well, but yes, you are, of course. If, we've had Minister for Private Sector Development.
Yes.
Right?
Private sector enterprises.
Yes. We've had Minister for Private Sector, Ministry of Private Sector Development. It would appear to me that if you are talking about public oversight, private profit making, maybe one day under Ministry of Private Sector Development, but that's when I look at the SIGA Act, right? One of the things when the SIGA Act first came, and we had, we did some work, and I looked at the SIGA Act. I was expecting to see in the SIGA Act some of the best practices that we would like our profit-making corporate entities to reflect, right? But you look at the SIGA Act itself, and the president appoints the Director General and the 2 deputies and managers and all of that, right? So from the very beginning, you are thinking, okay, this is the body that is created to oversee the governance of these important economic assets. And instead of using that law to more or less enact a framework of corporate governance that reflects how private sector profit-making entities must operate, right? You just start with the same overbearing presence of the president in appointing you, your 2 deputies, and all of those things, right? What model of corporate governance, if you had your way, right? And based on your experience, what kind of model of corporate governance would you propose for that sector?
I would still maintain the president appointing the Director General, for instance, but must be guided by the principles of private sector organizational structures.
So some qualifications for the director?
Yes, there must be. There is a qualification there, but it doesn't really come out clearly the person's qualities we're looking for. He must be private sector minded person. You're going to run a business. You're not basically a politician. But we have politicians. I was a politician, of course, and I went in there. The advantage I had was I've done my master's in business financing. And so obviously I could read all the financial statements and interpret them and look at the procurement and all that. But if you have a case of somebody who hasn't got a clue about financial matters and you put him there, you have a problem. And I can tell you, indeed, when I left, almost all of them who came in had to come and see me because they were politicians. And I had to guide them through that. But so you need that criteria to be set. The sad thing is that when you leave the president to do that to SIGA, then automatically SIGA is weakened. It's weakened. Because then you respond to the president. And as I said, the executive is so powerful in Ghana that everything is like, is a god and everything. To the extent that it is clear that we need even the Director General and the board to have that private sector mindset. We don't have it. So, for instance, when they are appointing the CEOs to all these big institutions, Cocoa Board and all that, it still becomes the same political appointments. And SIGA doesn't come in at all. It doesn't come. In fact, SIGA's Director General is appointed as one of the normal ones. But I would have thought that if we're thinking business, private sector, profit making, the Director General and the board must have come in first before the CEOs come in. Because then they know who is the shareholder here. It's the Director General. Who's the shareholder? It's not. But here it's a case when the Cocoa Board CEO is gone, the Ghana Gas is gone, GMPC is gone, and you bring the SIGA board. By the time he comes in, they're all established. And they drew him. And even the board appointments, I've seen letters from my side and even this administration, they are even constituting the board. Even the SIGA Director General is not copied. It's not copied. So the SIGA Director General doesn't know who are the board members of Cocoa Board. All he does is that they've been constituted, but then he's supposed to be shareholder supervising them. So we need time. Maybe, as you said, we can go on and on and on. I would rather take my time from what you've just given me. I would put pen to paper. I put pen to paper. Talk to you as usual. Talk to some of the colleagues we know. Ibrahim, Ibrahim and I contested SIC. He beat me though.
Who lost?
I lost.
It's important to state that.
I lost. Oh no, I didn't win.
Yeah.
I didn't lose. I didn't win. But we are good friends. Me and him go a long way back from the revolutionary days. So let's maybe find a small group. I wouldn't mind being a member or part of a smaller group and put pen to paper, so that we can derive the maximum benefit from our profit-making organizations. We are not doing that, but there are examples across the world. As I say, even the Chinese,
exactly,
they use them. They use them. In fact, they are vehicles who are buying assets in the U.S. The Chinese, whatever the Chinese go in, they use their state profit-making organization, and they encroach. They buy a whole street, they buy a whole companies, and everything that goes back to China. The same thing in Mexico, the same thing. So we can Pakistan. So there are examples about. We can use that. Thank you, sir.
Okay, one issue that was raised in your absence was this mixed bag of entities under the purview of SIGA. So we've learned that it's not just, in fact, my initial understanding was that the interest, state interest that is referred to in the SIGA Act or title were just in the form of equity interest. But it turns out that there are some entities that are state entities, but they are not commercial as such. They just raise money. They are regulatory bodies. They could be Food and Drug Authority, or they are not set up as commercial ventures, but they raise revenue through fees and licenses and whatever they charge. Or even, I don't know if Forestry Commission is one of them. But would you take those out? I mean, if you wanted, a real SIGA focusing on business, why would you include, bodies that just happen to raise revenue? I mean, it's not business they are doing. They just charge fees for services that they supply, but the goal is not to make money from business. And yet they are under SIGA. I mean, why? What's the logic? Or would you, in a reconstituted SIGA, would you take them out?
Kwesi, I agree with you. Indeed, the original thinking was the equity holding and the profit making and minimizing of losses. That was the original thing of SIGA. And I was involved with Professor Puplampu and Chiakwa, and that was the original thinking. We had a lot of, but along the way, somehow I can tell you why. It's also a power play. It was a power play because the profit-making ones, like the Cocoa Boards, and they didn't even want to be part of SIGA. They didn't want to. They thought, what's this person or another organization there? They are a country of their own, like Cocoa Board. I struggled to get their audited accounts. I struggled. I had to use my own, as you know me, my bullying tactics in some instances to rope them in. But once I left the scene and they noticed that the rest are just normal gentlemen, they go back to their normal self again. I wasn't a gentleman. I'm not. In a way, I can be a gentleman. I can also be a village boy in some instances. So you needed that rough tactics to rope them in. And so power play came in, and I must admit. And so we then defined the interests beyond the equity level. That, hey, yes, they are just taking fees, but is an interest? If they're overcharging somebody, why can't we bring them in? And then we also took even interest as even state lands. It was even a thinking that we should go for it because it's a state interest. State has interest. So the interest became very amorphous. So the definition of interest must be clearly stated. And for me, as you rightly say, let's take them out of this whole big thing. And with hindsight, that's what probably we should have stuck to the original thinking. Because really, it was a new thing, new beginning. Why don't you start from small level, concentrate on the few who are making us sweat, those who are taking a lot of revenue out of our system, and turn them around. Once that succeeds, then we can begin to see whether maybe the experience that SIGA's got, we can extend to maybe the fee paying and all that. We may not, but at least let's start with for making profit. But we didn't, so we extended. So now I agree with you that looking back and with hindsight, we should just concentrate, focus SIGA on business-minded approach in terms of government way of running our resources in those entities. That I agree with you.
Okay, I'll ask my last question, and I'll cede the floor to the participants. Some work we had done.
This is a power play. It also gave me authority to go and challenge the president. Because I had all these entities under me, and you cannot restrict me. So we had a banter. Sometimes we had banters. So my time at SIGA was not smooth, but I had to bully my way through sometimes.
That's why your tenure was short.
It wasn't short in a way, but when I ended it, it was like a banter. I had to just, thank you very much, I'm gone.
Then from there, you say, go and handle the chiefs. So one insight that we call these state enterprises. But if you look at the history, right? You look at the history from the beginning of state enterprises, 60s all the way down. I think I found a quote somewhere that they are states in theory but private in fact, right? They are state enterprises to the extent that we nominally own them. But if you look at the benefits that accrue from them and who gets them, the literature suggests that many of these enterprises are run for the private benefit of the insiders and their political principals. The state gets little from many of them. So, you look, examples, let's say Ghana Airways, when it was still flying. Those of us who used to take Ghana Airways had all kinds of interesting experiences, right? Whether you were coming from Washington or Baltimore or New York, you saw that the cargo hold was usually full of stuff that the crew and other related parties were bringing to sell in their own shops in Accra. It's a state-owned enterprise to Ghanaians because it bears our colors and it flies the Ghana flag and people feel emotional about it. But in terms of who really benefited from Ghana Airways, board members flying for free sometimes, all kinds of people flying for free, business class, you go there, everybody there is flying for free. So that observation has been made about a lot of the state enterprises. How much they pay themselves, what they use their money for. Some of them set up foundations without even statutory authority. Some of them do CSR on their own, unregulated. So to what extent are these entities, because that is for those who are pushing even privatization, right? So there are those who say, you stop worrying about these entities, bringing them into the constitution, just privatize them, because really they operate as if they are privatized already. We just think that they belong to us, but they really belong to those who run them. And they don't account to anybody. There are rules about financial statements. They don't follow them. They don't issue reports. What I think part of the challenge here is the accountability framework for state enterprises, right? That it is really, over the years, been a big drain. Some of them have a capacity to completely throw our economy into a tailspin if they are badly run, like COCOBOD. The volumes of resources that go through it, if it makes a very bad business decision, this economy, So what kinds of accountability frameworks are we talking about here? Maybe the standard private corporation accountability frameworks don't work very well because you don't have a typical shareholders meeting, you don't have the typical, the things that work. You don't have a stock market that disciplines your behavior in terms of the investments you make. You have the state, you have a political entity that is still the one that's doing the backstopping on the accountability side. How would you design this framework such that, if we are going to continue having these as state-owned enterprises, that we really get the benefit from these enterprises as a state, and that they don't basically put us at risk in the way in which they are managed? Because they are private, you say we should use a private model, but the private model on the accountability side doesn't work for state enterprises, right? It just doesn't work. You need some other more robust framework at the back end for them to work.
Prof, you're right. And there are instances where the sad part is also when they even create subsidiaries. And somehow those managing it sometimes doesn't even know. And it doesn't come through their accounting system. So subsidiaries, like, let's even put a case of VRA. VRA has got a housing company called Propco. Is it Propco or DevCo?
Propco, yeah.
Propco. There's nothing in their books that shows the accounting system of Propco in their management accounts or even their audited accounts. So I encountered them. I said, excuse me, what are you doing? You're pumping state money there, and it doesn't reflect in your statements, in your books, and it abounds. So you are right. We need a framework, an accountability framework, where it's spelled out in black and white. In black and white. What are the objectives setting up these state entities, and what do we expect from them? There must be clearly. Now we have moved away from the Nkrumah time where it was freedom. Hey, let's get a black man can do his own affairs, and we had problems from there. You know that the problem started from there, and we have not changed. The mentality is that we go there. This is the status. Nobody owns it, so let me take as much as I can and go away, and nobody checks them because the appointment system didn't work well, and it's a political appointment. So what I'm suggesting is that let's have a separate governance system and also accountability framework that clearly in black and white state what you are doing and what the state expects you and what are the returns. The returns on the investment the state has done, return on assets, everything must be clearly stated. And you are measured by that. In fact, your pay and salary must be on that performance. It's not because that's how we compare to other similar ones in UK and US. So that's how we've been doing. But they forget what they go, the stringent measures that they put through in the UK or the US. Here, no stringent measures. And in a way, it is also, as I said, it comes to the appointment system. That's why we need to curtail the powers of the executive too. Because I have had countless encounters with the presidency where they just call a CEO and give directions. Do this, and you cannot say no. Because if they do, they moved. So they are sitting there looking behind their back that there's a powerhouse somewhere. All they need to the president is calling me. The chief of staff is this. And they're all panicking. This is a problem in Ghana. Unfortunately, so it's also the caliber of people we appoint. Sometimes one person can make a difference. It's not easy though in Ghana, modern Ghana. But if you have a strong character who has been clearly told in black and white what is expected of them, and they are punished if they don't deliver, either through their remuneration or even to the extent of even prosecution, then we're going to have the same up and down banter. We'll never have an end. So I think, let me catch you, other we have a debate which will never end. I am in favor of sitting down, setting up a small group. You've given me a lot of stuff to think, and now looking back, there are things that I would have probably done differently. and maybe not extend my wings too much, because I did. In the end, I also wanted to show Powerhouse that, look, I'm here. I'm here. And in any case, I'm organizing all of them. And I pulled them to Akusumo. You, President, you better come. If you don't come, these are your men. Are you interested? And then you have to run. So it's also my power play. But for us as a nation, if we take that out and be clear in our accountability framework and in also their deliverables, then the power play goes away, and the appointment system, how is going on. Then you are there to do a job, come out. And in fact, maybe you are not there forever for the time of the presidency or the government. You are there to deliver, and you are given an appointment over a certain period of time, and moved. If you know you have a 4-year term as a CEO to run here, you are given your targets to meet every year. And if your targets determine your remuneration, you will deliver. If you don't deliver, I'm afraid there's another person who's ready to come in, and then we move you. So let's find time. And then it's an interesting area for me, because really we are struggling with our financing of everything in Ghana. We're looking at external borrowing and all that, whereas the money can be found here. I've even suggested at some point that if we run this country very well, we don't even need to collect income tax from anybody. Income tax, those small money you take from people, especially the lower level income tax. What for? If you run your system well, the resources are low in Ghana, both natural and human, and we can make money without taking income tax from the lower level employees.
Great, thank you. Dr. Nimoy Thompson's hand has been up. Doche, whether your hand is up or not, it's up. Okay, let me go around. Honorable Ayikwe to Senor, and then Dr. Jonah.
Okay, Prof, thank you. Yeah, I miss the gloom and doom. There's always the issue of daily graphic, which stands out as an exception. Perhaps we can even compare it to Ethiopian Airlines, in the sense that Daily Graphic is 100% state-owned.
Well, the board chair, the former board chair is here, so I'm sure he's happy to hear that. But he will also say something about it.
And sometimes it even pays, if not all the time, it actually pays dividends to the government. So what you call an accountability framework is probably just an issue of governance. The governance of the respective SOEs, once we've gotten rid of the OSEs, other state entities, and we deal with the core ones. We just need to put in place, I've always cited Daily Graphic as the evidence that, or proof positive that something can be done about these state-owned enterprises, and they'll play their role. And of course, there's the issue of their respective objectives. There are those, as you rightly said, that were set up for job creation purposes during Kwame Nkrumah's time. Profits, incidental, yeah, but it was primarily to create jobs. It was also the fad at the time. At the end of the Second World War, every government everywhere was creating state-owned enterprises. And where they didn't have them, they simply took them. So Great Britain, for instance, took a lot of, they nationalized a lot of, and then Thatcher came in the reverse. So there's an element of history. A lot, in our case, sometimes I wonder, for instance, why do we still need state transport? At the time we started state transport, there was no GPRTU or any of these things. So do we still need it? And similar other SOEs. So perhaps it's also time to review the relevance of some of these things. And then lastly, if it's just a question of profit, then why should government even go into it? Then any business can do anything and just make the profits and let the government just sit back and tax and get its share, as opposed to going into it. Again, it has a history to it, where once upon a time, we didn't have a private sector strong enough to go into certain areas, and so the government went into those. Now that we have a relatively strong private sector, why should the government insist on doing things that the private sector can do perhaps more efficiently and more profitably? And then lastly, there's the strategic case, the strategic imperative for the government being in certain sectors or certain areas purely for strategic issues, not necessarily for profit, but you don't also make so much losses that then you become a systemic risk to the government. So these are issues that I think we need to look at in terms of what to do with the state-owned enterprises in the wider definition of the public sector and the public services. Thank you.
Is it something that the NDPC has focused on? I mean, the National Development Planning Commission? Is it something within your purview? Have you focused?
With the larger issue of the efficiency of the public sector as a whole is very much at the top of NDPC's agenda, because in the final analysis, our ability to develop depends on the efficiency of these state-owned enterprises. Not state-owned, but all publicly owned enterprises. Some of them may be state-owned enterprises. So we look at VRA, we look at ECG. For us, it's critical to our development. We know that without electricity, nothing goes. So we can come up with a long, ambitious program, and there's no electricity or transport and logistics and things like that. So yes, ultimately, the capacity, our institutional capacity to deliver development, no matter what the setup, is very critical. And we do discuss that, especially since the public lately has been complaining a lot that, yeah, we have plans, we've had all these plans, and nothing seems to happen, nothing. There's a black box in between where we make the policy and where the results are supposed to come in. Something is happening in that black box that we don't see. And a lot of what we're discussing here actually relates to that. Why is it that we have these beautiful policies? And since I took office, I've been meeting a lot of donors. And sometimes they flatter me to the point where I actually blush as a black man. That as for Ghana, you have all the systems, and they compare us to other African countries. You have the system, you have this and that, but somehow the results are not showing. And these may be some of the factors in the black box that are impeding or preventing us from that. So yes, we are very much interested in that.
But do you see a role for NDPC, now that we are talking about, so you roll the SIGA entities, the commercial entities into the constitutional framework. Yes. And we are looking at the architecture of, how you do the oversighting and the governance and then determine which ones are strategic interests and all of that. Do you see a role for NDPC in that framework? So, for example, we're setting up, the conversation on natural resources, I wish that you were present too. Right. One of the interesting points made at that session was that if we had, we needed like an integrated natural resource, maybe not a body plan, whatever, right? Because we're a natural resource dependent country, among other things. If you take natural resources, if you take resources from SOEs and the like, clearly NDPC has to be interested, right, in how we fund the development plans that you generate, how we integrate natural resources into our, development ecosystem, whether to do industrialization and all of that. So given that kind of role that you play there, beyond just being interested in it as a subject matter, is there, you think, a role for NDPC in how we manage these assets, how we govern this structure? Or would your role be more like an advisory, think tanky kind of role for government in this setup?
Well, we did specify some roles in the 40-year National Development Plan, which, as you know, has been relatively dormant, but we're going to revisit that. We'll revisit that with different perspectives or additional perspectives to development. If you heard me speak in the past couple of weeks, I've talked about the centrality of productivity in our national development strategies. In the past, we didn't talk too much about it, and there was even a misconception as to what is meant by productivity. People thought that productivity meant producing more. But productivity basically is about efficiency, how efficiently you utilize your resources. In both the private sector and the public sector. Too often, for instance, we have the National Management and Productivity Development Institute, which tends to do more training for businesses and so forth and so on. But we have a more fundamental approach which goes beyond the private sector and also emphasizes productivity in the public sector broadly, how efficiently we utilize our resources, human resources, financial resources, material resources, time resources. I noticed that we started 10 minutes late. I would have raised an issue over that, because 10 minutes that we've lost forever. So we try to preach those things. And so productivity is going to be central to these things. And how much we get from those efforts would also depend on governance, how we structure things. Asabi mentioned the fact that we had SOEs that were going into areas that were not part of their mandate. We call that allocative efficiency. It means they are allocating the resources for purposes other than what they were meant for. And when you do the analysis, you'll find that we'll always lose money over that. And also, of course, it also goes into the issue of financing development. But when we take our turn, which is in like a couple of weeks from now, I'll definitely give you more substantive examples as to how we intend to restructure the whole thing. But for now, yes, one of the Commission's less explored mandates is its role as the brain trust for government, which we haven't done much of. We focus more on planning and to some extent monitoring and evaluation. Even monitoring and evaluation, we're going to change that to make government more responsive to public needs. But the brain trust aspect and the productivity, as for productivity, I can't stop talking about it. For those of you who follow Paul Krugman, the US economist, one of his famous sayings is that productivity is not everything, but in the long run, it is almost everything. And you only have to look, we measure, the most basic way, we measure productivity as output per hour worked. So it has not, well, it has something to do with production. So if you look at output per hour worked, and you compare, you do the global rankings, in the US, the typical worker produces $70 an hour. In Ghana, it's around $6 an hour. And if you break it down, and then we have a national minimum wage, daily minimum wage, of slightly more than $1, daily minimum wage. So you are looking at around 15 cents per hour versus someone in the US who's producing $70 an hour. The federal minimum wage is $7 an hour. Some states pay as much as $10, $15. So there's a huge gap. And the only way we can close this gap and also retain skilled Ghanaians in Ghana is for us to be able to do what? Be more efficient. And that calls for these kinds of institutional reforms, process reforms, and many others. I think during the net, I gave an example of me clearing a little speaker from SEPS that I brought with me, a small speaker that I put under my desk in the office to play Bob Marley and Bernie's piano and all that. It took me almost 2 weeks to clear that speaker. And I was given 28 pages of paperwork. Now I could have cleared the same speaker in South Africa because I used to order stuff from China. I could have cleared it in less than 15 minutes with zero paperwork. Everything was done here. So you see the gap, the disparity, where something that could be done in 15 minutes with zero paperwork was done in almost 2 weeks with 28 pages. That's a cost to the economy, cost to the individual, and so forth. So we are looking at these issues, and as I said, we'll produce more or provide more once we take our turn at the hearings. Thanks.
All right, Doche.
Thank you, Mr. Chair. I want to start by saying that my comments are very specific to state-owned enterprises. So I'm not talking about the OSEs and the other things which are under. So I'm not It's on, actually. Well, yeah, thank you. So I'm not talking about, can you hear me now? Yeah. So I'm leaving out the OSEs, the regulatory bodies, the forestry commissions, and so on and so on. They're important, they're interesting. Their issues probably have a lot to do as well with the Public Services Commission and so on. Interesting issues, problems to be dealt with, but that's not what I'm talking about. I'm reacting a bit to the chair's, shall I say, provocation or invitation. I think commercially oriented state entities, state enterprises, are here to stay. So I don't think the debate about should there be or shouldn't there be is, I think that debate is basically settled. The question may be which ones should there be, what should they cover, should you create new ones, and what criteria apply, and so on and so on. But I think my basic premise is that there is good reason why the state is owning commercial entities, and that's not part of the debate now. I also agree that we need an accountability and governance framework for those entities, given the experience that we have had. I mean, the Ghanaian story, there's a lot to be said. And I'm very excited to hear my old friend Asabi, who I haven't seen for some decades. I'm happy to see him, but I was very interested in everything he said, because that's the voice of experience dealing with the Ghanaian state-owned entities. And lots of what he says is important. And I like the fact that he says there should be more discussion of these issues and a more focused approach to making recommendations. But the skepticism that I have, and that is where the chairman's provocation comes in, is that I am not certain that the Constitution is the place where these matters are primarily dealt with. Clearly, constitutional review presents an important opportunity to deal with big questions, and so I understand why that discussion is happening. I think the discussion about accountability framework should certainly be advanced. It should happen, and if it's not happening anywhere else, it should happen here. But in my mind, the Constitution is not where most of these issues are going to be addressed. The Constitution is not going to solve these problems. And just as we heard that even though there are provisions to deal with the other entities, and as the Public Services Commission representatives explained, there are lots of constitutional provisions in the other areas, and there are still lots of issues. My argument is that while there's room for some statement of principle in the Constitution about these commercial entities which have been excluded from Chapter 14, the important work has to be done at a different level. It may be the level of legislation, it may be the work of figuring out what makes sense for these entities, how to develop an accountability and governance framework that works better than what we have got so far. That's important, it needs to be advanced, but most of that it's not the Constitution that is going to give the answer. At best, the Constitution may have one or two sentences, state some very general principles. For example, say that state-owned commercial entities should be run on some corporate governance principles. Some formulation, you can have that in the Constitution. But beyond that, the answers to the problems that we have had are to be found in a little more work looking closely at that experience, and that's why I'm excited to hear Asamoah Boateng talk about his experience, and some prescriptions for dealing with those which could end up in legislation. I would just to give an illustration of the general point I'm making, and I don't want to take up too much time. if we said, for example, that with the constitution that we have, with the legislation that we have, if everything is exactly as it is without any change, if we said for any new administration, let it be understood, if we could persuade any new administration at any time, that for all the appointments, whether to boards, to chief executives, whatever, of state-owned enterprises, we have a SIGA. All proposals for appointments should start from SIGA. So whatever, the presidency is where the final approval is given, but the administration of that appointment process, the whole business of how it works, it starts somewhere else. If it means that the political people will go to SIGA and do their lobbying there instead, well and good. But let there be a process such that by the time it gets to the president, or even if the president, has some people, the president's say is based on some administrative work, some criteria that are established, and that then provide, there's a framework within which this power is exercised. So I'm saying that even if nothing changes in terms of legislation, in terms of constitution, if it was understood and accepted that this is how it should work for the SOEs, we would be in a different place from where we are.
Good.
Sorry.
Well, thank you, Mr. Chair. I think I share some of the views that he has expressed, but some of us who have been around for some time in this room now understand that it's not strictly only going to talk about the Constitution, but we have a general discussion on some of these things which might influence how to deal with the SIGA statute itself. And so the discussion now is in twofold. The first part is SIGA and how to strengthen the statute setting it up. The second one is how to bring it or them under the public services. And I am looking at a very simple rendition. If you look at 191B, it says public corporations other than those set up as commercial ventures. So that is what takes them out. So what about a rendition 191 expanded to add the words SOEs or state-owned enterprises set up as commercial ventures subject to the provisions of the Companies Act 2019, Act 992. So in one fell swoop, we bring them under the Public Services Act and at the same time make them subject to the Companies Act of Ghana.
Interesting. So you raise another interesting issue, which is that these different forms in which our public sector entities operate. In fact, I was going to ask the Public Service Commission people about that. They mentioned this project and then this, but there's this bewildering array of entities, office, board, authority, company, commission, corporation. And, one day I was talking to someone, he says, Kwesi, all those things mean something. They mean money. If you lobby to get yourself from one status to the other, it makes a lot of difference. We in the public, we have no clue why they are not all called the same thing. Apparently, it matters whether you are authority or you are a commission or you are this and that. And we have also created in the SIGA sector this interesting dichotomy now between those that are registered under the Companies Act and apparently those that are set up by statute directly. And I hear, I don't know, that one of the things that separates the ones in the Act, somebody says, well, oh, but if you're under the Act, then you can do more things than the one that is set up by statute can do in terms of, your autonomy. You can borrow against your balance sheet, and the sovereign doesn't come in, it shouldn't go. So all of these things, I'm saying that this level of confusion, right? The state is the shareholder of all these things. Should it matter the form and which, the legal form which their incorporation or their creation takes? But somehow we have managed, whether on the public service side, on the non-commercial side, or the commercial side, to create all of these different things with apparently implications for a lot of things that we don't know. That should it matter, the state is still the shareholder. Whether you are incorporated under the Companies Code. I mean, I don't know how the state, if you are incorporated under the Companies Act, how does the state do an annual general meeting? It sits by itself in the Ministry of Finance and votes and says 100% of the vote, I vote. I mean, it doesn't seem to me to matter very much, but somehow we have managed to make them matter in ways that affect the governance. Because apparently if you go this way, you can escape some scrutiny. If you go that way, you can come under different scrutiny. And so some of that is what, I agree with you that we can fix this, we can bring them simply in, under 91(1)(b) by just removing instead of saying other than commercial ventures, including the ones that are set up as commercial ventures, and quickly we bring them in. But then that means that they are now part of the public services, yes, which we don't quite, we are saying maybe public service. Then maybe Doche's formulation means that you give them to another body that initiates all their hiring processes and appointment processes, and say, the hiring of CEOs shall be done by a body set up for the purposes of regulating commercial whatever, right? And then you just do one or two principles. But what I thought you were also going to say, and based on the fact that you've been in the room for quite a bit of time, is that part of the conversation we have had before this is that given our culture around legislation, right, and given the kinds of culture that has developed around how we view law and the hierarchy and all of that, sometimes you put things in legislation and it's just gone, right? If you have a culture where people think that it matters most when it is prescribed, it's explicit in the Constitution. That's part of the advice some of the people who have worked this Constitution have given us. Be as prescriptive as you can be, because knowing who we are, we will find ways to evade, gray areas and stuff like that. So for you, Doche, I think the point is, I get your point, right? But if you are operating in a legal culture like ours, where we are given to finding gray areas for the purposes of evading rules, and where unless the thing is in black and white, unless you have bright line rules, we tend to fudge on the edges, right? How exactly do we do what you are proposing? Be very brief, one or two sentences. Huge amounts of money are going through these entities. We've talked about the systemic risk that some of them even pose to the economy. And yet, it's just one or two sentences in the Constitution about how we govern and hold them accountable. Would that be sufficient given the kinds of, issues we are talking about and the culture that we operate in? I think that, for me, that is my main concern. If you can reflect on that, but then we can go to, if you haven't exhausted your point, then we can.
I understand, but I thought the whole idea of this constitutional review is that for most people, it has served us well for 30 years, but it is not leading to development. We have made provisions that creates the impression of a democratic state. But the Constitution is not helping us to develop. So we should now look at those aspects where we can do these prescription things, to try and reorient people's attention to development. So if you have set up something for commercial, as a commercial venture, and it is not performing, now you want to do something to let them know that they were set up for commercial purposes. It is not just one of the state enterprises like GBC to give us public service, but they should make sure that they are making profit. And that's why I'm proposing that they should be subject to the Companies Act. So the orientation right from day one, when they put you there at SIGA, it's not that you are just going to be part of the public services, but your duty is to ensure that you work and make profits, bring us revenue, give dividends to government at the end of the year. Thank you.
Chair, it's just a quick thing. I think one of the major challenges we had, and my honorable, he's also a chorister in my church, Calvary Methodist, so Asabi, is the fact that if you look at SIGA's Act, I see a major weakness, even though it's there. All the sections and others say that you make recommendations to a minister. And that is a major challenge. The weakness is that they cannot take any decision. All that they have to do is to make a recommendation to the sector minister. So unless there's a change in the architecture, as we talk about the power play, there is a power play, but the act itself makes them very weak in terms of what has to be done. He was using his own political thing to push it. But so long as you have a weakness in the act. Secondly, you find out that
yeah. It depends on where you are sitting. Very clockwise. All right, Mr. Chairman, I fully support the Public Cooperation Commission. It has to be totally decoupled from any suggestion around the Public Services Commission. Its nature will be definitely different, and I think that the commissioners around that will also have to have a different character from what you naturally have with the Public Services Commission. My problem with the Constitution on that part is the inclusion of corporations. Now we have multiple corporations, some that are commercial in nature, others that may not be commercial in nature. So you take a lot of the regulatory authorities, they are not supposed to be that commercial in nature. But we are talking about a gold board today. Gold board is going to be by an act. Technically it is a corporation. But it's a commercial entity, even though it also has regulatory functions from what they are designing it to be. So we'll need to clearly define commercial corporations from that. This whole exercise of commercial entities, we have to situate it properly in the space of policy. They are policy institutions. They are not just profit or, no. And the objects are very different and may vary and evolve from time to time. As governments, they would definitely always need to have institutions somewhat in this character. One, to operationalize policy and actually pave way for private sector investments. You can't always have a situation where everybody owns a rail track on his own. So in some circumstances, certain kinds of infrastructure would have to be managed by the state. An institution would have to handle that. So the SOE thing has income. It also has policy operationalization, because there are certain frontiers which can only be broken by state capital and state risk. Private capital may not be able to open or break some barriers. So that's what some of these institutions would have to do. So they would definitely need to fit in somewhere. The argument about China and co, let's be very careful. We have to create our own Ghanacracy. Just don't look at the term democracy and somebody is doing it, we are working around it. The culture is very different. We have achieved statehood as a country, but we have failed to achieve nationhood. Ghanaians don't mostly see themselves as Ghanaians. Easily their tribes, their religion even rank before the state Ghana itself comes into play. Other than that, the graft and loot we see in this country, he said, because it's more legal in structure, for 30 years we still have a country defined as Ghana, and we are not killing ourselves. So at least for now, statehood, in some sense, we don't have nationhood. So state institutions would always struggle with the value you see from the Chinese entities. It comes with a certain pride to have actually broken frontiers for a Chinese institution. I've worked with them. We've done business together. And you see the energy, the orientation. We don't have some here. That's the language that we speak. People can't understand why you have a certain kind of government job and certain things will be happening to you. So we don't have the right orientation for that kind of one. Come and look into our institutions. Dr. Adani, Nimo, you are very wrong about Graphic. Graphic has made losses 3 times in a row up to 2023. Graphic is a dying institution. Yes. In fact, Ghana itself has not always been a failing institution right from start. But today, we are where we are. The problem you have, look at all the SOEs. They said it was only 2 that seemed to be making profits. All of them were fraudulent profits. COCOBOD did not make profits, you and I know it. But on paper, because they are doing some funny cash accounting, deferring liabilities, and ripping investors of their money, they claimed they were making profits. Bust, take out the 400 million Ghana cedis that the state gives it every year through a boss margin, even though it runs commercial operations. Add the 2 billion that losses it has created in the Gold for Oil program at the Bank of Ghana. Then you realize that there's no state institution that is really making any form of profit. COCOBOD's own is the most reckless. Because when you think about COCOBOD, which is a monopoly, remember the word, monopoly. How do you lose money as a monopoly? When that happens, then you know that the fundamental structure around these things have failed. Just as we have market failures, clearly we are having government failure. What is the cause? Only one word, governance. So if you want to fix this problem, you have to fix it at that particular route. I have my commercial activities both in commodities and also in oil, both on the policy front and then also in the operational or the commercial side. I remember my engagements with Tor. When you had crude deliveries you wanted to make to Tor, Tor had directors who were all political appointees, a CEO, political appointee. Sometimes the people don't even have any clue what refinery economics look like. Commercial sense, almost negative. And you're having a negotiation over crude supply, and somebody's looking for a cut, which will say just $1 on a barrel. But when you look at refining margins at the time, the total refining margin that the entity would possibly make may just be $2. One guy wants $1, another board member wants 50 cents, another one says he's a super cargo, he wants to have 50 cents. But at the end of the day, how would Tor ever make money? The orientation of state-operated institutions in this country are misaligned with the commercial orientation of philosophy that make commercial organizations survive and thrive. So if you don't fix that part, we have a fundamental problem. How do we possibly fix this part? One, back again to the governance issue. While we may have our public corporation commission in place, question, who is really going to be there? Who is appointing who there? What's the basis upon which the person is there? If it's still going to be another political structure where the president and the party politics of the time will determine who goes there, then we should stop wasting our time. Let's have lunch now and go home. If we can't fix that fundamental problem on a commercial institution and rather make the bodies that define and manage this process more dominant by professional institutions that are hopefully more independent, and we still go back to political power, we'll have a problem. All of us sitting here, anybody who's run a business here can take all the president's SOE appointments, and you can tell that if you owned that company, in fact, the president himself, if he owned the companies and it was his own, he won't appoint most of those people. You won't appoint them. So why are you appointing them? It's politics. So you have to deprive him of that right to make that kind of appointment. So we have meritocracy really shaping what happens. So I would rather look at us having a provision for sure, but having a body which is less party politics dominant in determining who is there, and rather have it more driven by professional representations. The politics should be there. SOEs are very critical. I think when you still have political representation, it should also be across the divide. Our constitution has failed to achieve the development, as our former Attorney General just indicated. And it's because it's been very exclusive. So even where politics must be in place, we must have an orientation of creating an inclusive political environment. If we are having the commission, we should have fit and proper, these words are very critical in what you capture, fit and proper the requirements for people to sit on particular commissions. Do we have it? No. The Bank of Ghana does that for financial institutions to help mitigate the kind of market failures we've had. Do we have that for our organizations? Absolutely no. Even if politicians must nominate people, there must be a fit and proper criteria. For a commission like this, again, I go back to my two testing. Everybody must go back and let's have consensus on the quality and the professionalism of the people who are put in there. It must cascade down. Governments will have to use these SOEs to drive and achieve policy. So there must be policy direction. You can't run away from that. I want to achieve this in policy for these kinds of institutions. That is clear. There must be transparency, clear transparency in the parameters that are set, the KPIs that are set for these institutions. The boards of the SOEs will continue to fail. The MDs will also continue to fail if you do not depoliticize or departisan politicize the governance structure, even in the unit SOEs, because now the commissions are the shareholder in trust for the state. That's what effectively they have to hold the boards accountable. So there must be a very transparent criteria. Everybody boss is supposed to achieve in commercial sense every single thing. Everybody should know. There should be a parameter that makes everybody have visibility in that. The transparency must be there. But if you're going to have party apparatchiks appointed to sit on the boss board, you won't achieve anything. How do we fix that? Would also be shaped by this broad framework, which will be drawn from the public side of politics. I chartered accountants, you can't come and misbehave. If everybody sees you are misbehaving, very soon you have to be replaced in some form. The CEOs who run these institutions must also now become professionals. I agree with the recommendation that was made earlier that these things should emanate from the boards. It should emanate from the boards and the commission. If you want to now send names and people to the president for him to select 2 or 3, means that at least you make sure you send 3 very competent people in there. But his ability to fire that CEO is not arbitrarily done from Flagstaff House. It must be done through the board, who would have run an objective process to justify why this person cannot continue to hold a particular position or the other. So largely this is for me, we have to deal with that particular governance structure, else we are just speaking nice grammar.
Round, and then we can break for lunch because it's about almost 2 o'clock.
One last note, Mr. Chairman. You know, my brother here asked me to do some job I didn't do. He was trying to suggest that we cannot always be taxing the people, but the government really needs income. So we should allow more state-owned. And I said, where is the income? We are making losses. Who said that the people in the organization are not even taxing us by chopping and driving, flying, anyhow they like?
You know, I mean, when we come back from lunch, you should think about, I think the point you made about these institutions not being just commercial entities, but also being policy and institutions is actually an important point, especially for big ones like Cocoa Board and GMPC and others. There's certainly a policy element there, and how we capture that policy role, including the systemic risk that some of them pose, by completely depoliticizing their appointments is, I think, part of the challenge we have to wrestle with.
Yeah, Prof, thanks, and Senior, thanks for the great points made. I associate with all the comments made, but what I'm picking so far shows that all these discussions ought to be situated, or a clear provision ought to be made to cover these things in the Constitution. Why so? My point is we need to identify what is the problem that we seek to solve. And the problem which we seek to solve is inefficiency in the management of these SOEs, resulting into losses which are ripping this country of resources. This, in my view, this is the basic problem we want to solve. What are the root causes? Key has to do with political influence, as we have all discussed. And who has this power? It's the president. 195 is clear. The appointing authority is the only person who can politicize the entire process, like you have mentioned, by appointing the wrong persons, as we are discussing now, into those various roles. And there's no way that power can be curtailed without a proper provision in the Constitution. So it will really be good for us to be clear in our minds on that. The issue of privatization and taxation of the private sector, as opposed to allowing the SOEs to function. I'm a qualified tax person. I believe that we are not performing very well in terms of our tax levels. Tax to GDP is still low in Ghana. But the point is, have we run a taxable economy that enough that we want to do tax to GDP of 18-20%? The answer is no. At this point, if we also do not put in proper mechanisms for these SOEs to begin to generate the type of revenue we require to run this country, I was very happy when I heard you say that we should get to a point where revenues from these SOEs should come to the point of allowing us to even drop the idea of taxing people within certain brackets. Why? Because we are even using our tax systems to create inequality. We are deepening inequality in our country due to the tax systems that we are running. Can we get replacement, as you have suggested, through these SOEs? Why is it that the same companies, if privatized, are able to make more returns for their private owners, but if it is owned by the state, it doesn't make the profits that are needed? It's the same human beings that run these companies, whether in the hands of the state or in private hands. And so the problem has to do with the undue political influence, which must be curtailed through a clear provision in the Constitution. That idea is highly supported. I move to discuss the last one, the issue of key performance indicators, which you've mentioned. The SIGA Act must be clear on that. And how can that happen? That can only happen if the leaders of these state-owned enterprises are independently appointed. But if they are politically appointed, how can you measure their performance on what grounds? Because you've not allowed a person free hands to run the institution. So at what point can you turn again and say that you did not achieve your indicators and so you are going to be fired? And so for me, the provision is very critical. If we miss this opportunity, then what we are saying is that some 20 years down the line, we might meet and be talking about the same things again. So the depoliticization is very, 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 very critical. I think I should end there. Yeah.
All right. Dr. Jonah?
Let me just take 2 quick points.
Do you?
Yes. Sure. Okay, thank you very much, Mr. Chairman. I have just 2 questions for Honorable Asabi or any other person who can help us with this. And just want to draw from your experience with respect to the various hats you've worn in the past. Just want to find out from you, what your reaction would be if we included a provision in the Constitution, which clearly indicates that the CEOs of such business, state-owned enterprises must, in a way, show demonstrable business acumen. In other words, they must not just be appointed because they are politicians, but they must show that from their previous life, that they can manage business and make it profitable. Will such a provision be something you would consider from where you sit? Then the second one has to do with another provision which can indicate that the appointment of the Director General or the CEO, and which can be renewed subject to performance. So that in there you have, yes, or any of these institutions under SIGA or by SIGA itself, you have 2 years, and it's subject to renewal, but based on performance. In which case, your tenure is secured for 2 years, but at the same time, if you don't perform within this time frame, you know that you'll be shown the exit within a short period. So I want to pick your mind on these 2 items. And the last point I make is in relation to what Honorable Aikweotu said about the Companies Act being subject to the Companies Act. I agree. But I think that we should go a step further to indicate that you must make profits. And the reason is that you can be under the Companies Act but be limited by guarantee. And so we should be very clear in the spirit of what we've discussed in the past, that we should not leave doubt in our drafting. We should be as prescriptive as possible. We should say what we mean and mean what we say. Otherwise, somebody will just come and set up a limited by guarantee, and you will not make the point. So we should be in there that you've been set up solely for the purpose of making profit, and we should not miss the opportunity. Thank you, Mr. Chair.
Joe, by the way, in your absence, the earlier praise was taken back because somebody said graphic has been making losses. So.
Yes, Mr. Chairman. Asabi, I want some clarification. I think we are all agreed that a certain autonomy is required, autonomy from political interference and so on is required for these profit-making state institutions to progress. Now, I have two queries that I need clarification for. You said that SIGA must have a link with the Public Services Commission. Now, you also said that, if I am referring to you rightly, that SIGA must have a minister or come under a minister. Am I right? Now, my question is, under a link with the Public Services Commission, what are the benefits for the institutions we are talking about? What benefits do they derive from being linked with the Public Services Commission? And then also, if we want autonomy from executive influences and interference, Then, why must it have any relation with a minister at all? Why must it come under some ministerial authority or supervision?
Thank you. Since it's lunchtime, I think I've also.
I think after lunch, we can take all the questions. So we'll just let. Yeah.
I think we discuss that.
Sure.
After lunch, we'll go into detail. But as I said, briefly, the Act mentions a minister, so it's there already. And I mentioned that if only, similar to what Senor and the former Attorney General said, if the particular minister is appointed based on a certain criteria, not just a political person, but we know he's going to oversee a commercially set up entities, and the criteria to select him is clear, then the president knows he cannot appoint any Tom, Dick, and Harry politician to go and do that job for SIGA. It's possible. The problem is that we've left these appointments open to the president to do what they like. And there's no guidance, there's no guidelines for them to do that. That's why. In terms of linking to the Public Service Commission, the Public Service Commission and even the CEOs, they are public servants. In fact, they are supposed to be public servants and do a commercial job. We are running a country, we are running a nation where you and I, if you are called to service, and being a CEO it's called to service. You must understand that. So you are not there to manipulate the system to your benefit.
Asabi has used Takashi to disrupt the thing. This is how he used to do it at SIGA. We were supposed to go around like this. He has commandeered the mic. This is how he used to run SIGA. He bullied his way through all the time.
I had to also show us a powerhouse here, and everybody was listening to me. But I think that you taking the Public Service Commission out entirely is not ideal. It's not ideal. Because you are CEO, yes, running a commercial entity, commercial mindset, you got the qualities as a business guy to go and do it with all the governance structures and the accountability framework we've given you. But you must also know that you are called to service. It's not your private job. And so that's why the Public Service Commission, I think, must always have a link. Either we create not a structure, but interrelationships, where maybe every quarter or every half year there's a convergence zone where the SIGA boss or whoever the structure there meets there, and then they can iron out some differences that, hey, you are there running a commercial entity, but don't forget you are not here to run your business. It's a state entity. It is our business. It's government business. So that's why I call for a link.
Okay, Dr. Jonah.
Well, thank you, Mr. Chairman. Okay, my name is Kwesi Jonah, as the chairman mentioned. Mr. Chairman, considering the loads of wisdom that we have absorbed in the past 1.5 hours or so around this table, I don't think it's even necessary for me to talk at all. But listening to almost everybody who has made a contribution this afternoon, it is quite clear the kind of challenges we face in managing our state-owned enterprises, particularly those that are gathered on the SIGA. The challenges are clear. Many of them are affected by the wide appointive powers of the president, political interference, limitless opportunities to exercise political patronage, and many of the enterprises in there we call profit-making. The better description would be loss-making. There are very many of them that are making losses all the time. Now, this means that if we want to rectify the problem, we should not take an approach that says only the Constitution can fix it. We should be able to ask ourselves, are these challenges that we can solve without necessarily incorporating everything into the Constitution? So for me, the question before us this afternoon is to incorporate or not to incorporate into the Constitution. That is the question. So let us be very, very careful the way in which we want everything to go into the Constitution, because many of the challenges that these enterprises face we can deal with them without necessarily going into a textbook type of constitution which prescribes in detail what decisions we should take at every stage. That is my contribution.
Okay, so I think we can conclude. Yes, I think you can have the last word, and then before lunch, and then we reconvene after lunch to have another maybe an hour and a half before 4 o'clock when we will close.
Thank you, Chair. Very quickly, just to again respond to what Prof had said in terms of the relationship that I believe Honorable Asabi was, referring to. If you look at our submission, the submission from Public Services Commission to the CRC, as Article 196. Where our functions are clearly stated in existing constitution, we are actually asking for the introduction of some other extra functions, if I should put it that way, in terms of governance functions, right? Where, because today we believe that the governing boards and councils are not assessed, by, as it were, anybody, any constitutional body or anybody for that matter. If there's anything at all today, it is more of just a peer review, which in itself has, the challenges. And therefore, we believe that if that kind of relationship should happen between PSC and SIGA, it is around the governance function that PSC can then become the body that actually works with the governing councils and the boards in terms of performance management, in terms of assessment. And if all things being equal, that assessment and evaluation then becomes an advice or a recommendation from PSC to government or to the president, in terms of which board or council is performing based on the KPIs that have been agreed, and of course, the function or the performance of the CEO then, feeds into what the governing council is. So I think that is the kind of relationship, we are talking about. And today, as we see, the existing situation is that SIGA is part of the central management agency that, has an, PSC has an oversight. And that agency meets every quarter. So I think that we can still create the synergy and create that functional relationship if we want to really get the best outcomes for the country. Thank you.
So I think you'll all agree that it's been a very robust morning of very engaging issues, a lot of learning, and clearly, for me, a good amount of incremental knowledge acquired through this exchange. So we're very grateful for all of the presenters and the commenters at this session. So we'll break for lunch, and we should, so it's 2:15. and the afternoon sessions, early afternoon sessions. So we'll probably use this last session to wrap up, to, probably for our purposes, we need more concrete, very specific kinds of proposals. I think Dr. Kwesi Jonah left us on the note of probably going back to Doche's point about, to include or not to include. And I think that is indeed part of our task, but I think, it's probably not as binary as to include or not to include. It's also, if to include, how much to include and what to include, right? It's really more, on many of these issues, because they are already in the Constitution, it's really a matter of, what and how much to include. The only brand new issue is really this SIGA issue, which is completely outside of the purview of the Constitution. But I think that the general sense is that given the significance of that sector, both in terms of the volume of public resources that go through these entities, as well as the systemic risk that some of them, notably Cocoa Board, GMPC, and others, might pose to the economy at large, it would be a bit awkward to have a constitution that regulates pretty much the nature of the state and its dealings with all kinds of entities, and yet excludes this particular sector. So, we take Doche's point, but I think we would like, to get more concrete proposals on some of these issues. Again, learning from our predecessor commissions, especially the 2010-2011 Constitution Review Commission, there are some things that we can propose for legislative consideration. So if we decide that this matter should go into a statute with these principles as the guiding principles, then that's what we will do, right? So if we decide that it doesn't belong in a constitution and that this is best or better dealt with in a statute, then we can name those things that should be are better dealt with in a statute. So it's whether or not it's for us or for statute, I think we are still interested in hearing from you on those issues. So we are back on the same two issues: public administration, public commercial sector, and the related issues. From yesterday's conversation, one of the things that came out was compensation, remuneration in the public services, and especially the inequities and disparities that have been caused by the carving of many different services, or the splitting of the public services into all these multiple services, and how that has affected compensation and grade levels and other things in the public services. So if you are in the legal service, for example, you have your compensation scheme is linked to the judicial service or judiciary, and then creating situations where some entry-level person in the legal service would be earning, more or significantly more than a director-level person in, say, the civil service proper. And then when you throw in the SOEs, I think the distortions multiply and become even more complicated. So that's, of course, that is not something that you can normally deal with directly in the Constitution, but these are some of the things that we picked up yesterday. And as we've been talking about the losses, somebody said we should be calling them loss-making as opposed to profit-making. I wanted to ask this question. I don't know who can best answer it. But when you look at a number of the SOEs, at least when you look at their income statement and their balance sheet, they're not making losses as such, right? If you take it, I mean, they may make profit, but they have huge expenses, right? So you look at the income statement, you'll see that actually on the trading side of things, they probably made a profit, a gross profit or something. But then when you net all of the expenses, including salaries, compensation, whatever, then you get into red. So, I mean, if this was a company, let's say if this was an oil and gas company, foreign company under the control of the Petroleum Commission, you would not allow that kind of practice, right? Because if a company came here and said, look, yeah, we made a profit nominally on our operations, but we have all these expenses. And I know that Petroleum Commission, for example, regulates what it accepts as cost or expense of an organization or a foreign entity under its jurisdiction or mandate. And I'm thinking, a number of these state-owned enterprises that we think are making losses are actually not making losses, but they just pay themselves and basically just impose a lot of cost on the state so that they don't have to show profit or pay dividends. And the compensation is one of the things that I think has come up in this kind of conversation, and how that kind of practice, if we're going to tighten legal regulation on the SOE sector, there are a number of practices that immediately come to mind, how they build up their cost. Some of these practices around corporate social responsibility has become this new area. When you go to India, for example, there are usually laws around CSR by state entities. Because otherwise, the state needs money. It set up a company, and the company is just doing charity work with the states, the money that the state has essentially generated. And these are some of the practices that I think, create public agitation around some of these entities. So, we can talk about how we streamline practices in that sector, what the role of the Constitution, what the role of legislation, and how we could. So these are just some of the additional thoughts that come to mind on my side.
Okay. Thank you, Prof. I think those are very pertinent reflections. And I think it all boils down to the issue of governance and associated issues of transparency, accountability, censure, if need be. So, for example, if we were to revisit the issue of governance in state-owned enterprises and come up with not just performance indicators generally, but key ones relating to performance per se. So, for example, we can replicate what pertains with listed companies. I think the first month of the end of every quarter, they are supposed to produce their financial statements and everything. We can have similar things for the public sector, where the CEO knows that he could lose his or her job if by the end of the following month of the quarter, they have not done this. So pretty much it takes us all the way back to the issue of governance, the details of which may not necessarily have to appear in the Constitution, but we have to recognize nonetheless. Because a lot of the things they do that they get away with, you cannot do that in the private sector and get away with. That's why I have a problem with the blank or the loose use of the term commercial entities. They are not strictly speaking commercial. They are more quasi-commercial. But in real commercial activities, where we have the Unilevers and the big ones, you can easily get fired for not, not publishing the necessary reports or misusing. But this is not the case. So I think it's a critical and very pertinent summary that you just made, and I thought I should support you on that. Thanks.
Chair, linked to that is this whole issue that we did yesterday came a professor. The professor gave a lecture on values. Professor Kwasika. Values. I think it's very critical. This whole business, whether it's state enterprises or whatever it is, what is the underpinning view? And as we have that properly articulated somewhere, and each value properly explained. I mean, there was a very simple thing that those of us who love football saw. The Japanese, they go to football match. After the match, they clean their portion of the stadium. At the World Cup, whatever, well, it's values. They will never leave bottles scattered, no. They will not say, somebody is paid to do that job. It's value. So I think whatever we are doing, governance, I agree, financial management systems, I agree, performance management is key. But I think we need to begin this whole business of looking at what are our values as a country. I mean, propose a very simple one, Ghana first. And I think we can even articulate Ghana first in the various dimensions. So that if you're in charge of a CEO, is Ghana first. What does it mean, a state enterprise? What does it mean for us, Ghana first, as a CEO? So that's a bit. So our values is one of the things that are. The second one, I think it's an operational thing, but I still think it's critical. We talked about the mapping up of the state enterprises environment. I think that's more for legislation or anything. The current thing of amalgamation of everything under SIGA, I think is a problem. I was talking to Absabi that at long last, you have repented, you become born again. When they were doing this business, in one of the meetings like this, interfaces, I said, no, Absabi, those areas, standards boards, forestry commission, all those things, their core mandate is not money making. The money making is just ancillary. It's something on unintended consequences. And you don't have the capacity to manage that environment. So that should not. It became even an issue between, I'm aware that PSC and all that and all that and all that. So it was good to hear him say that, upon reflection, but as he said rightly, it was more of power politics. I think the mapping and the separation is clear. Let's have an agency, somebody responsible for the management of that particular agency. More management here, quote unquote, is more of the supervisory, the frameworks, so that the people are still independent, either using the company's code or whatever it is. So I think that is clear. And then all the others, and I'm going to be a bit provocative. There are a lot of organizations that have no business being on their own out there services. I think as a nation, we also need to have a framework. I don't know whether it should be in the Constitution, but we should have a framework for establishing a service, an authority, or whatever it is. We should have that. And it should be very rigorous. This idea of everybody getting up and saying, today I want a service, just because the moment you move out, have a service, depending on your capacity to make noise, your salary goes up. And it's not correct. So that's the bit that I'll say about the state enterprise. But all the other things that have been said, about governance, about separation, having other mechanics. The other thing I want to talk about PSC, since they are here, is that if you look at the original intent, PSC was supposed to be more of a strategic, overarching body, setting standards rightly, monitoring, ensuring that things are done, and compliance. I think somehow their law has gradually moved them into the realms of operations. And I think that's something that you see, it becomes a problem. Because once you start moving into operations, then if you're not careful, you lose the oversight function. Years ago, there used to be a body called National Oversight Committee for Reforms. If you did analysis of the outputs of that reform intervention, I always say it was because they were called oversight, so they lost sight of what they were supposed to do. That's just on the lighter side. Yeah, their side went over. So I'm a believer in a strong public services commission. I'm a believer in a strong public, setting the standards, making sure that the rules are there, monitoring and exacting performance. But I shudder to think that the gradual move into some of the operational things. For instance, I don't see why PSC should be doing schemes of service for organization. No, I believe sincerely that PSC should set the guidelines. When Prime Minister Buzia established the management services, that was for the public service as a whole. So management services would do the scheme of service for the organization, and then PSC will validate it and make sure it works and make sure that they implement it. So that at least you have a double kind of you have somebody doing the operational dimension and then another body seriously looking at it and making sure it's done. So I believe in a strong public service commission because a lot of the challenges that we have in this country, on the governance side, on the administrative side, on the firing side, with a strong employee. Now, how do we empower them? One of the things I was going to propose is that can't we allow PSC to go to court to enforce some of their directives? How can somebody go through PSC, be appointed, a legitimate process, 6 months, 3 months, and then simply because it happened after 8th, the appointment letter was issued 8th, that if they went through a proper process, we say you cannot appoint. I struggle with that because if you really have an understanding of how this process of recruitment goes on, you should not. So should we not have a system where PSC and other enforcement mechanism, can they go to court to challenge some of these decisions?
Are they currently barred from going to court?
I don't know about that.
You cannot sue your government.
No, I'm just going to enforce, but there should be possible because if it's not being done properly, because a lot of all this hula baloo is because things are not being done properly. And once a directive is being issued by PSC, everybody must respect that. So that's
but you would think that the affected employee or the affected would have standing to go to court, right? So if PSC cannot go because the HR manager cannot sue the chairman of the board,
I'm talking about enforcement of the directive of PSC.
So which again? So how is that? I mean, which you raise an important point. What's the connection then between? Let's say if Shraj was playing, and I'm not. I mean, let me rephrase it. If we take Shraj in his ombudsman role, right? What's the relationship between PSC when it comes to these kinds of things? Somebody has been dismissed without just cause. Somebody has been deprived of their appointment and all of that. What currently is the nature of the relationship between PSC and Shraj in its capacity as an ombudsman or in the work it does with administrative justice?
Let me read it out to him, because that is where I was looking at. 218B, to investigate complaints concerning the functioning of the Public Services Commission, the administrative organs of the state, the armed forces, the police service, and the prison service, insofar as complaints relate to the failure to achieve a balanced structuring of those services or equal access by all to the recruitment of those services or fair administration in relation to those services.
Yeah.
I
So
think
this
there
is
is a
right.
provision, there is a right, there is a procedure.
This is 218B.
B,
And that's right,
218B.
chapter 18.
On Shiraj. It is already there. Sometimes these are some of the difficulties. We don't read through the constitutions well, or maybe we defeat ourselves by saying that, oh, we can't sue government. The right is there. That go there. The people are doing recruitment. I ask myself, you always rely on education, entrance exam. But they just bring people to you without entrance exam. And this is taken care of. And yet we say there's no remedy. There's a procedure, there's a remedy. 218.
Yeah, no, I think the relationship between SRAC, and I don't know if it's a matter of who came first, and therefore, there's always been PSC, in our system, and maybe they've developed a tradition of just doing some of these things on their own. But I've always wondered how very little of SRAG we hear when it comes to the public administration. And yet SRAG's origin is as an ombudsman. I mean, that's the public admin, like a referee or, So it's,
That's why I'm raising it, because it is specifically provided for, and the public services is also mentioned, and the complaints that he's talking about, equal access by all to the recruitment of, and we are doing protocol, and you are looking on, and what our former chairman of Civil Service Commission is telling you, that you can go to court. You say, well, I cannot sue my own government. What about this provision?
Can I chip in here? I think that what Chairman is trying to ask is also important in terms of who invokes Strategies function that you referring to, 218B. Will it be PSC, or will it be the employee who has been aggrieved? And I think PSC will struggle, because I spoke to Mr. Ajimai, earlier on, to find out who is their legal advisor. Because it's very important for them to know who is their legal advisor, because that person will help them to kind of, one, interpret their functions in the Constitution.
If it's the Attorney
Just
General.
like the CI hasn't been created. Meanwhile, it's in the Constitution that you have to create a CI. And he said it's the AGs. So they lean through the AG. So if you are getting your legal advice through the AG, then is it the AG that's going to actually invoke this 218? It's going to be difficult for them in that regard. And so having those autonomy when it comes to the legal structure within PSC is very, very important, because then it gives them that, not independence, but that, exactly, for them to be able to kind of complain or invoke certain things whereby the executive kind of overshadow it. So it's because the AG is not going to obviously sue himself.
As a former AG, I think.
Let me throw light on this as well. I served on the Regional Lands Commission, and I noticed that every time they are running to AG, and I asked them, what does your provision on independence says? You are an independent body, so why do you have to go to government? Is it not the same situation here? Are you not an independent body? So why do you go and rely on the Attorney General to do anything for you? Recruit your own lawyers. And from that time, we decided Lands Commission is going to have their own lawyers, no more Attorney General. Let them work for them.
But
Chair,
you know,
can I just a quick?
I'll see the ground for you shortly. I noticed that we we have developed from the Constitution constitutional law, but without an equally robust administrative law regime. I mean, a lot of, what our Constitution does that's different from a lot of traditional constitutions is that it almost constitutionalizes administrative law too. But the administrative law is very weakly developed. So you have a constitutional law structure where if you had this provision in some constitution, let me say even Kenya, right, where the administrative law system as I know it is actually much more robust. If you had 218 and you had the provisions we have in the Public Services Commission, you would have seen a connection between what the Public Services Commission does and what SHRAC does. So, for example, you would have seen the creation of something like administrative tribunals within the Public Services Commission that become the first layer of complaints around abuse of office or power. And then there would be some kind of an appeal of sorts to SHRAC. But I noticed that that relationship is never developed here. And SHRAC is just sitting somewhere. Few people go to it with any of these things in spite of 218. So sometimes I wonder what we've done with administrative law since the Constitution. It's almost like we are just constitutional law, but administrative law is a huge part of the public law that is sometimes completely missing from the picture. And I don't know the solution, but a lot of the things that we normally would go to the judiciary for, ordinarily, if we had developed the administrative law system well, we should be going to an admin tribunal that sorts these things out first.
Hello. We also provided Article 23 of the Constitution, which provides that administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law. And persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. It's there.
But we haven't created any tribunals, have we?
Well, we can use a SHRAC as a tribunal. Any person who is aggrieved by their decision, you don't need to know. Go see a lawyer. It's not your duty to know the law. Go and see a lawyer. He will read it for you. So these things have been well crafted. You have to be fair. You have to comply with the requirements imposed on you by law. And if anybody who is aggrieved should take it up, anyhow he thinks he should take it up, he must be able. So we thought this one together with 296, would do the trick for administrative, bodies. 296, which provides on the exercise of discretion. Exercise of discretion.
Yeah, 296, yeah. ABC, yeah.
That where in this Constitution or in any other law, discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. The exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. And in fact, C even went ahead to say that where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or a statutory instrument regulations that are not inconsistent with the provisions of this Constitution and that other law to govern the exercise of discretionary power. As usual, this matter went to the Supreme Court. Supreme Court, it will lead to constitutional, something melts down.
Nuclear melts down.
Nuclear melts down. So they should not publish any sentence. This
It
our
was a silly
Supreme Court again. Created confusion for everybody that you don't need to publish. We were then, I think, on the EC that they kept exercising their
I remember
discretion
that matter.
and creating all sorts of constituencies.
Without
They
any-
don't
any
tell us how they are
methodology or
doing that.
anything.
And so we fixed them under this one, took them to go, oh, no. It will lead to nuclear meltdown. They should not publish anything. But at least A and B are clear. 29296 A and B on what administrative bodies are supposed to do.
But I thought, Mr. Attorney General, on the administrative tribunal issue, right? Isn't it the job of your office, your former office, as Minister for Justice, in the Minister for Justice role, right, to assist, so if the Public Services Commission, as the HR, strategic HR manager for the public services, even in my little organization, the HR does some grievance, there's a grievance procedure that my HR administers. And there will be a small body of 3 people if you have a grievance. So if the PSC had, the public services had a tribunal, and it was linked to the SRAJ's administrative justice adjudicatory function, that kind of setup, if it were there, it would deal with a number of these civil service grievance problems. But shouldn't you be the one setting it up? Shouldn't the Minister of Justice be the one that is trying to help set this kind of structure of administrative law up in our system? Because we are not familiar with it. The civil law countries are very big on admin law. And I think the common law countries, not all of them are. Beyond the ultra vires doctrine, we haven't developed that very well. But some, for example, in Kenya do a lot of admin law in their system. But I think that it's a very big gap in the way in which our dispute resolution system works in the public sector. If we had an admin, a good, maybe lead from the Ministry of Justice, some of these gaps could be solved.
Well, I agree with you. Governments will come to power with a manifesto. And I've said elsewhere that the Attorney General is never independent. So he will sing the tune of his master. And the legislative program, if we want to deal with domestic violence, and it's one of the things we have promised, that we come and start looking at that one. So it is for the Public Services Commission, other bodies who need certain laws to write to the Office of the Attorney General to bring his mind up to that look, don't you think if we do ABCD, it will work? Because to pass legislation, you need a memorandum to tell us what you want to change. Why are you proposing this new law? And you also need a cabinet buy-in. So you need to go to Parliament to convince them why you want to do a particular law. And if the thing doesn't affect us, immediately, but people are talking about high-profile cases, how to jail the opposition. You see, how to jail the opposition members. You think you will have time to be thinking about these things. So they should begin to think about it, that they themselves should be writing to the AG, calling for laws. Especially, I remember in my time, that they tell you that independent bodies have no minister. So the Attorney General should be their minister. So if you have any problem, always go to the AG for whatever advice that you need. So all of them should suggest some of these things to the AG and hope that when it goes to Parliament, Cabinet will buy into it. Because you prepare a whole memo, you go there and it is shut down. That's the end. It is shut down. Nobody wants to buy it. You understand? CI. They are CI. They should think about it. Because if the thing is raised into the status of law, it will be better than these things we are holding about policy, huge policy documents.
Yes, I agree with the AG. But you see, our act, we have a new act which is before the AG. A number of these issues have been raised. For example, in our the draft bill that was submitted to the AG, we said that we should be made into an agency that can sue and be sued. The AG shut it down and said that we are, and that's the first time I was hearing about that, this thing, that because the commission is composed of members, it cannot have that. That's the first, this thing. Two, because primarily our roles are to advise, 195 is to advise the president, 196, you cannot have that. So, in actual fact, we would have to depend on the AG. That is the current, this thing that they've written to us. And that even electoral commission, technically, you cannot sue the electoral commission. You sue the AG and the electoral, and it's the AG that represents the electoral commission. Parliament, you sue.
No, the AG has its own lawyers.
Oh, then,
yeah,
no, we can have, what they say is that we can have our lawyers to advise us, but primarily
to represent you in court. No, AG
is the one.
EC has its own lawyers.
But AG is the one that will represent us. Our lawyers will only support the AG. That is what they have indicated. So currently that is there. Then we had to discuss issues of complaints panel. We used, instead of a tribunal, that we have a panel, which is in. There's no this thing, but the idea is that it should be the commission itself. It comes to the commission, then commission sets up. So it is not as if it is a permanent panel, but as an ad hoc. Anytime, because the issues will change. You have issues of labor and others. So immediately you have that petition, you set up so these are issues that have been addressed in the new thing, but it may not be strong as we are envisaging here, because what happens is that after the Public Services Commission, the person then has the right either to go to the Labor Commission, if it's a labor issue, or to go to Shraj, if it's administrative, or to go to court. So the issue is to have it such that the person who has filed the complaint then has the power to go to whichever forum the person thinks. So this is what is guiding the new act. Having said that, but I just wanted to make a comment on what Nana raised, the remunerations. When I went to the commission, I was somehow, what word should I use? Confused. I wasn't going, I thought I would use horrified, but confused is better. I realized that, let me put it, they were talking about, as a head of civil service, don't let me use mine otherwise. For the head of civil service, you realize that more than about 40% of public sector workers will earn more than the head of the civil service. And that is supposed to be, in the past it was a ministerial decision, 40%. His Excellency the President, about 20% of will earn more than he does. I'm not worried if it is performance related, but what is happening in the past, and that is that one entity, in 2021, we interviewed a director. What we do is that because we issue out the appointment letters, we know about everybody's salary in the state, even though we don't now set the salary. So in 2021, 21, the basic of that public sector, a director, and that is not even the highest, was 30,000. Another director of the same institution came up, and it was almost 50-something thousand 2 years later in 2023. So who increased the remuneration almost 100% within 2 years, which is not in line with the other public, and it is the boards. And you see, the boards are supposed to, liaise subject to the approval of the minister. But boards, especially the non-subvented boards, because their salaries are not, it doesn't go through the mechanized. The mechanized is the controller and accountant general. It doesn't go through the mechanized. They determine their own salaries. And that creates a problem. So if you even have these emoluments and allowances, you would always have to do with the basic salary and say boards will allowances and others. The boards will increase the allowances to more than the salary, because there are some agencies, the allowances are over 100% of the basic. So in curing that, it's not just, with the experience that we have at the public sector, it is not just setting up an emolument, this thing. You need to be able to address it. Initially, there was only one band when this thing, it was a single spine. Now there are more than 5-6 bands because of what you have. Non-subvented, they have energy sector, has security, has this, has so many bands. And the idea always is with the implementation and not the intent of this thing. So it was taken up, and you think that under the fair wages and others, there will be it does not work. Non-subvented is a major challenge. And so we need to critically study the whole this thing and then look at what works. Otherwise, we will be putting things in the Constitution thinking that it will cure this thing, may not necessarily do that. And that is something that, it was a shock to me to see all these. And that is why people are moving from the civil service to agencies. Yes, because within, oh, all right.
Chief, what they wanted to move, the salary proposals that they had included, that was supposed to go to the office of the president, was way out somewhere. They were quoting rates related to foreign service organizations, not even in Africa, outside of Africa. And that was almost nearly granted. If it had been granted, so these people are here today, they are the same level, next time, and it's 300, 400%. That's what we are talking about.
Yeah, but how do you tame, it's already happening, those who have taken themselves out
yes,
have already managed or succeeded in getting this different treatment in terms of remuneration, whether it's security services or legal service or whatever. How do you put the genie back in the bottle? It's already,
but
a
that's what we said, that if we have an independent, first thing is the way the current arrangement is, it allows, again, go to the presidency. It allows the president, the authority, to do outside. This whole thing about the judiciary, it did not go through any process. The judiciary went to the office of the president, President Mills' time, and I wouldn't say they deceived him, but they were strategic in their presentation. That this relates more only to the Supreme Court judges who were then a few, and the Court of Appeal, something like that. Without mentioning the issue of relativities across board, and going as far as the legal service people. So that was approved. You see, so that was a strategic. So it was approved before, when it got to Ministry of Finance, then they realized, no, we are not talking of just 10 or 20 people. No. We are talking of all the state attorneys. We are talking of this. We are talking of this. And so that's how it is. So again, it comes to whether this independent thing, the removal of some of these things directly from the office of the president. That we're talking about reduction. So if this independent body is strong and is properly empowered, fully, but I know we have a problem there because the judiciary says third bodies, they are not they don't report to them and all those things. So the Constitution, in crafting the independence, let me tell you, a time ago, I was a chairman of, that was a long time, we call Government of Ghana Manpower Budget Hearing. That is where you come and you explain why you want an increase in staff. What have you done? Where are the efficiency gains and all that and all that? The judiciary came first year. When they asked a question, a set of questions, and they realized that there were no efficiency gains anywhere. The second time when they were invited, they said, no, that body was part of the executive. They don't report to the executives. So they won't come, and that was it. So they went out. And so this issue of independence and all that and all that and all that has allowed a lot of these things. So in the crafting of those words, shall be independent, what really do we mean by, is it in the performance of your judicial function? But I know the argument will be, we can also be sabotaged because when there's no money, then we can't perform our function. So these concepts are very important for, as we draft them. We need, you see, some of these things are there. The way we craft these things, independence on its own and all that, are part of the problems that we've created. So yes, let's have an independent body. In remuneration policy, you can't bring the people down. But you can have a system in place where you can even redo job evaluation. And if it's across for everybody, then over a period of time, we can deal with some of these. But currently, the way it is, it will continue. There's a standard for giving the salary of Auditor General staff. It's been agreed. There's no law, but it's been agreed as a matter of principle. It's there. So it's all, as long as that, again, another principle that they are independent. They are independent. So virtually, they decide how much they are paid. Virtually. In one way or the other. It goes to the president. But you know, realistically, no president will really want to directly want to be seen to be antagonizing the Auditor General. Other they will say he's against the Auditor General performing their function and all that and all that. That's why this independent body with the necessary technical support is established. And that's it. I was happy when PSC was part of the remuneration business because they were really not in that category where people will be paid by heart, because they were also subject to all these single spine business, their staff and all that. So then they would have been, if for no other reason, for the fact that yeah, bread until we will also manage. But now that's been taken away, all the others, they are just moving on. So I think strongly and independent, but across the public service. And that's a difficult one. Across the public service.
We will be talking about independent constitutional bodies, I think, tomorrow. But
Chairman, but for the judiciary, it appears that the Constitution gave them that protection in 127. Sure. 1271, in the exercise of the judicial power of Ghana, the judiciary in both its judicial and administrative functions, including financial administration, is subject only to this Constitution and shall not be subject to the control or direction of any person or authority. That's why when people go there, they sack them based upon Article 127. That is not only their judicial function, but even administrative and financial. So they will have none of that. My worry with chairman's submission, that I remember he said something like, an act has been used to amend the constitution. Somebody said it here, that an act has rather been used to amend. I will demonstrate what I'm talking about. Go to 196, your functions, and get to the end bit of it. The establishment of standards and guidance on the terms and conditions of employment in the public service. Standards and guidance on the terms and conditions of employment. Today, somebody is telling us that, it is rather the Fair Wages Commission. You see, but there's something we call public interest litigation at the Supreme Court, where you don't need to have an interest in the matter. So you think if you have approached somebody to go to court to say that what they are doing there is wrong, it is inconsistent with or otherwise contrary to the provisions of this Constitution, and that the Fair Wages Office cannot exist to do what they claim they are doing for public service.
Or that it can exist only as a unit or as part of the Public Services Commission.
Of the Public Service Commission or something.
Remuneration certain functions.
Because otherwise, what has happened is what you described. An act has been used to amend the Constitution, when it is the Constitution which is the fundamental law of the land.
I think I need to also chip in here. Earlier on, I was when we were discussing the CI and all that, and also when the PSC needs to invoke the when there's any agreement and all that. I think you are struggling in terms of the AG being your legal advisor. So I was thinking of, in terms of recommendation, whether we should probably in the Constitution try and decouple the Law Commission from the AG's office. Because at the moment, the Law Commission sits under the AG's office. And in the UK, they are an independent commission. And they lean more towards the judiciary. And that is where they do, and you know how the UK system is. Their laws, the parliamentary, because of parliamentary supremacy, they can change their laws like that in a day. And so if you're struggling to actually create or come up with your CI and all that, when the Law Commission is an independent body or lean more towards the judiciary side, when you have any issues with even your CI, they can support you. You can get legal, because the Law Commission is usually, they recruit as lawyers that are supposed to go through the Constitution, go through the Acts of Parliament and all that, and try and come up with CIs and SIs and all that. I struggle to see their function being part of the AG's office or the Ministry of Justice in a way. So perhaps as reviewing the Constitution, we probably need to look at where the Law Commission sits, because at the moment I really don't see their function in the country that much.
The Law Reform Commission is not it's not a constitutional commission.
The Law Commission itself, yeah.
No. It's part of the AG's outfit.
Agency under
Yeah.
the
So we don't actually have a law commission.
No, we do. We do have a law reform commission, but it is part of the agencies under the AG.
But the point is, can't it be independent?
It's not an independent. It's not.
Can't it, though? What I'm saying is, going forward.
They used to have their meetings at my office. They don't even have a good office. I served on it for like 8 years. You know, I offered my offices conference room for our meetings. They don't have any money. You know, it's you know, this issue of the remuneration and the independence thing. You know, there's a practice that I think, I don't know to what extent, Nana Jamina, you would think this practice also drives this independence thing. The linkage, the automatic linking of independence, or our conception of independence, is the judicial model. Whenever we want to make anybody independent, organization independent, we just use this simple linkage. Your salary shall be connected to Court of Appeal, High Court. Now, I don't understand why we have ended up with that practice. The judicial model of independence is not the only way to make a body independent. There are many, many ways you can give security of tenure. You can give it very specifically. You say, you serve for 5 years or 10 years, renewable once. You don't have to link it to 70 years or 65. But somehow, almost automatically in our law, in our constitution, whenever we want to make a body independent, we have found a very lazy way of doing it. I'll just link it to the judiciary and then we forget it. Which creates a lot of interesting, when you look at most other countries, the EC, for example, and I'm just picking one example, or the NCC, there are ways in which you can create an independent election management body without saying that the person that has been appointed must stay in office until they are 70 years. It doesn't happen in most places. The fact that the Supreme Court judges or Superior Court judges and the Supreme Court sit until 70, that is not what makes them independent. There's a way in which judges globally, that practice has grown, that you secure them until some age, but automatically, whenever you want to do anything that's independent, we just quickly tie them to the judicial age, and then we stop at it, and everything just carries on. When in fact you could deliberately provide for how they must be independent. You can give their security or tenure provision, you can give all of those things. But that is not what we have adopted. So it creates, the moment you link it to their salaries, then everybody wants to be independent and wants to be tied to their salary. And so that also drives this independence agenda in the public services. If you succeed, you are very good at making your advocacy, link it to the judiciary, and then that's it. Bingo, you are gone. Right? So it's also some of these kinds of drafting practices, or I don't know whether it's a drafting practice or it's a, but that is the model we have adopted. You look through Kenya, look through Tanzania, Uganda, nobody does it that way.
Agree with you, but we also need to look at the history always will drive. There are certain agencies which are very, I'll put it, powerful in dealing with the government, legislature, because of the independent bodies and the universities. So you would want to guarantee this thing, you would want to link it to one of the powerful independent bodies. Because I can assure you that...
How come that they have... The linkage, the only thing the linkage has achieved is that it has connected their salaries to the judiciary without making them equally independent. Yeah. So none of the independent bodies has managed to get the independence that the judiciary has, despite the linkage. Right? So in a sense, the kind of, what we're trying to achieve was to shield these bodies from political manipulation and interference. And we thought, the way we do it in the judiciary is the best way. So let us just link all of them to the judiciary, and that way we'll protect them. But has that been achieved?
Chair, the alternative, we should look at the alternative because of the executive overreach that we were talking about. The only way you can, because if you do not link, for example, we're talking about, let me give removal, and you've linked it with the appeal court. If it is a stand-alone, and you have even made these provisions, and it's not linked to the judicial thing, the executive may attempt to remove these so-called, let me put it, at that time, the independent bodies. What is preventing is the fact that because it's linked with the judicial system, if I have to be removed, then there has to be an appeal. It goes to the same process. And you know how strong the judicial system, you have the Supreme Court having, if it is standalone, I can assure you that EC public services charge will be removed in a moment, in a twinkle of an eye.
Not necessarily, right?
And what saved, Chair, what saved, for example, if you take the current Shraj and Dom Levu, who they said were late appointments, was because at that time, the remover had to go through this system. And there was no way you could say that in the judiciary, that appointment, late appointment, is enough grounds to remove that. So in looking at strengthening the independence, for me, if you have a strong body that you have to anchor that, that is the best way. Otherwise, we may have a very good idea, but tend to weaken this thing. That is only a caution that I am giving. And I think that is where almost all this thing have gone. Last, this thing had to do even with the remuneration. There were certain times the independent bodies had this thing in looking at remuneration reduced. They then had to go and say, we are at this thing before. We need to be careful.
We need to be, but we also need to be mindful of the kind of country we are running. I mean, this country is broke. Part of it is public wage bill. We are talking about a constitution in which we are saddled with all kinds of agencies or bodies, boards, governing councils, a lot of which, if we did the mapping, with your help, if we did the mapping, I'm sure that we could agree that many of these things are not adding value to the governance of the country necessarily, right? So if we did that kind of diagnostic, it would reveal that, we've created a lot of these things that are piling on the public payroll and yet are not adding a lot of value. And then we find a trick, which is, retire on your salary. And then we go and put it on we take the judicial model, they retire on their salary. So now I don't know. I hear that, military, wherever, immigration, everybody has taken themselves out of public services, found a way to link it to the judiciary more, and everybody's retiring on their salary. At some point, we have to figure out a way to run the country and figure out a way to rationalize these things so that we just don't use the public office as just a way to pile on more obligations on the Treasury. And I don't have an answer to it, but I think we have to find a way to do this that is better than the way we are doing it, because it's just not working. It's just not sustainable the way we've done it. If it was limited, just small number, but it appears that it's become a loophole that now everybody wants to take advantage of. Linked to the judiciary, then you get to retire on your salary. It means that presidents come and say, well, even if I sack this person, it's not a big deal. I can put my person there. They are still retiring on their salary, even though they are at home. They are getting paid. So why are they complaining? Go and sit at home but it's a cost to the state. And you see these, governments come, presidents come, and then they just sack people, and the person doesn't go to court. Why? Because they are retired on their salary, and they are sitting home and collecting pay. When the pay of the officer they sacked, the new incumbent goes up, they also get paid, the new raise. I mean, I don't know of another country that does that. I don't know of another African country. I mean, yes, of course. Of course. With pay and pecs. Because it's not coming from the pocket of the person who sacked them. They are not paying for it. I mean, what's the incentive to stop him? He wants to vacate the office and bring his own people at no cost to him. So this is going to continue.
constantly out there begging for money, while countries that can actually afford to do that don't even do that. And we spend so much. So can we, somewhere in these hearings, find space to make some recommendation for reconsideration? Because frankly, a lot of the things, and this is why we keep going back to the IMF, a lot of these things are embedded in our institutions, and they simply do not make sense. You look at, for instance, starting with the president, we treat the presidency in Ghana as if it's some divine position. The president doesn't pay income taxes, he pays nothing, he retires on his salary. Everything free, free, free. Compare that to the United States, which has the largest economy in the world. They can afford to pay their president $10 million a month if they want. I think he makes $400,000 a year. He pays income taxes on that. And believe it or not, every month they actually give him a bill for the food he eats in the White House. It's not free. And when he doesn't retire his salary. And this is a very wealthy country. And here we are, a poor country, with all sorts of perks that make absolutely no sense. So perhaps this is, if we are aiming at a developmental constitution 2.0, because 2.1 was 2011, then maybe these are sacred cows that we must be prepared to touch, because they simply make no sense. You did make mention of a bloated public sector payroll. Again, another paradox comes up, where the public sector payroll is bloated, yes, but you won't believe the number of vacancies in the public sector that remain unfilled. Wow. Because there's no money to pay. And yet, the public sector payroll is bloated year after. It doesn't even relate to the government of the day. The last numbers I checked from 2008 to 2023, we had exceeded the public sector wage bill every single year by an average of 10%. While we are falling short of revenue. Consider this, the whole thing doesn't make sense. So we're exceeding our wage bill by 10% on average and having shortfalls in revenue by 4% per year on average. And another 4% in shortfalls in infrastructure development. So how are we supposed to develop? We will remain in the IMF forever. Forget about 17th. We'll go 18th, 19th, 20th, as long as these things remain. So we need to perhaps take advantage of this momentous occasion or whatever to see if we can make some proposals to maybe the current generation of people who benefit from these perks. We can pay them out of the system. Yes. And then at some point in the future, everyone, including the president, the only president I've heard promise to pay taxes if he was elected was Kwesi Ndu, maybe because of his American background. But everybody else. And meanwhile, the number one citizen in the country pays no taxes. And someone mentioned Ghana Airways earlier in the day. I think you mentioned, when you got back in the day, you see, and I remember I used to take Ghana Airways too. You see these big bags, and they all have castle, because they didn't pay taxes. There was free VAT, but they have, so we are draining ourselves and somehow thinking we can develop. So please, let's consider that. It may be a dangerous proposition, but as I said, perhaps we can cover ourselves by letting the current generation, we'll pay them out. How long? 10, 15 years? They leave. So thereafter, we are all in the same thing.
No, I think, I mean, basically, I cannot help but agree that these are some of the structural rigidities we have built into the system, right, which narrows our policy envelope, our fiscal envelope, and we can't make a lot of moves. But I agree, if you just, you grandfather, the current generation who are on it, and you say, you just set a date, by which a new scheme operates, it would work better that way. But it's
Mr. Chairman, just
4:15. One of our members be calming down, please. So I agree. I think that certainly part of the challenge we are dealing with is that everything that may be good to change has constituencies of interest around them. right? And which makes it a hugely political exercise, trying to move from stage A to stage B. And maybe what you propose is one of the ways to deal with that problem, is that, okay, in order to manage the politics of reform around this issue, you just grandfather the current beneficiaries of the system into the reform and say, okay, once because you cannot, in the Constitution, you can't step them down, you can't take their privilege from them. So the only way you do it is just let it run its course for current generation, and then you block it. And then say maybe starting time T2, a certain period of transition is over. If you don't do that and you reset the clock, this is going to run the country aground soon. There's just no way this is sustainable. So it's one of the challenges that is beyond our committee, that we can propose it, but in terms of the cost of the transition is so huge and political that we have to have a different process to manage it. But I think it's something we need to do, because really, if you look at it critically, it's not sustainable. It's just not sustainable. I mean, I don't know any country that does that, where lots of people are.
But some of these radical things in Kenya, it was successful because they carried the people along.
Yeah.
The people were involved, they were interested, they saw the need for a change. If it becomes an elitist thing where your report is completed, then it's sent to the presidency, and then that's all, we are not good. But it was really a popular kind of thing, moving from place to place, people really dealing with this, so that those radical things, proper rational, all those, that's why it was possible.
Yeah.
Other than that, we need radical things, because we are talking of, it's not correct. So many things. Duplications. We set up these things all over, agency, service. And the cost of just two agents, actually one agency, pays for the whole of the civil service. One agency. Yes, one agency. The analysis has been done. One organization. Take all the whole of civil service in terms of remuneration. And when they say, and they call all of us civil servants. When the sins start happening, they say the civil service. They forget that. Yes.
Then they split it up. No, Mr. Chair, this is not very central to, but just a minor issue of concern, since we are talking about salaries without taxes, blah, blah, blah. Nana, and maybe Prof, you may know, all of the people who are on retirement from the public services and are serving on the Council of State, they also are in the category. At the Council of State, do they receive salaries there or some remuneration there? But if they do, would it not be a violation of collecting double things on what do you call it, the consolidated fund?
If the Constitution gives it to you, it cannot be. it cannot be wrong, right?
I see, Nana, you are saying that perhaps there should be some kind of a mass movement behind this. You are provoking riots. You see, no, because the kinds of things we are talking about here, if it's on the streets. No, because, these are so annoying. You see, as I've been telling my colleagues here that the lessons we are learning here, for me, the conclusion I come to is that this democracy is being reduced to a shell. The inside is so rotten by the people we put in charge of managing this democracy. It's like eating the inside out and leaving a shell. And if inexorably, if we are not careful, the end result is a total collapse. No. I'm just seeking your. No, it's frightening. It's very frightening.
Yeah. Okay. I think we've had a wonderful session, both morning and afternoon. We are most grateful to the Public Service Commission for coming today and helping to, take the conversation in another direction, building on the conversation that we had yesterday, and also to Mr. Samuel Boateng for enlightening us on the SIGA issue and then helping us to basically it's not presenting. No, he agreed that he will not present. He will just make contributions. Yeah. I think this is really this first engagement has helped us to define the scope of the issues, the critical questions, most of them unanswered. We just really want to be able to frame the right questions and get some thinking on it. Some of these issues have already been flagged here, so this is additional reflection that helps us to basically understand some of the content here, but some of them are new. For example, this whole conversation about state-owned enterprises is very new and extremely helpful. So we'll take this on board. This is not the only engagement. Most of the issues are overlapping. Tomorrow's conversation on independent constitutional bodies and executive advisory councils, which we understand those to mean mostly the Council of State, but all these other service councils, which are in the Constitution: Armed Forces Service Council, Police Council, Prisons Council, National Security Council. Those are the ones we are looking at tomorrow, but with the independent constitutional bodies. So EC, SHRAJ, NMC, Auditor General, those bodies. As you can tell, when we are thinking of independent constitutional bodies, we don't think about the PSC. Even though roughly the same language is used, but it's the same language with the Lands Commission. And anybody, if you tell the Lands Commission, anybody that the Lands Commission is also independent, they will laugh at you. So we know that the language is the same roughly, but I think the common understanding is that those are not necessarily part of what we consider independent constitutional bodies. But the same things will come up here. Some of the same conversations around linking to the judiciary, all of that will come. So if you are free and able to contribute tomorrow, I think you are welcome to join us tomorrow. Oh, really? Oh, I'm told that tomorrow is oversubscribed, so I should under-advertise tomorrow. So, and that is partly also why we don't, even though this is not a closed meeting, we tend not to advertise the stakeholder engagements because the forum is small and we have identified stakeholders that we have invited. There will be a public forum, open-ended, around the country. We'll start from Accra. The dates will be announced. We have dates announced already, but because of the holidays that were announced, it's thrown our calendar a bit out of gear. So there will be another opportunity, more open-ended, which will start in Accra, travel up north and come back south throughout April and early part of May. Then we will come back to Accra. Some of the unfinished business, we'll have to invite you back to help us think through them before we start in internal deliberations and then the report writing and all of that. So we hope that we can carry you along as we go through the process. For most of us, a hugely big learning experience, but it's not something we can do without you. So we will call on you again as resource persons at some point to come and assist the committee to put a lot of these things into text and see how it looks like in reality. So thank you very much. Meanwhile, your turn will come. We'll announce it. The NDPC is a big part of the conversation, but as you can tell, I think it's good that you're here. We would have loved for you to be here with the natural resource conversation, because there were some interesting ideas thrown up around that. I think you would have helped us reflect on it. But we will see, when we engage you, we'll ask you those directly. So thank you, everybody. It's about 4:30, and I think it's a good time to close. Thanks. Bye-bye.